Check. Hello. Hello. Check. Hello. Check. Hello. Check. Check. Hello. Check. Hello. Check. Check. Hello. Mic testing. 1, 2, 3. Hello. Check.
Hello, check. Hello. Hello, check. Hello.
Good morning, everyone. So this is just a formal attendance of the presenters who are going to present today for session 3, that is corporate governance in digital age. So can you just raise your hand if you are present over here? First is Kiranmai J and CS Pawan Kumar B. Okay, thank you, ma'am. Second is Vara Lakshmi M and Dr. Salaj Petkan. Okay. And third is Neeta Reddy Mosali. Okay, cool. Thank you.
Hello. Yeah, I'm going to take another roll call. Is Dr. Preeta S here? Okay. Rakesh Chandra Sharma. Ashita Mathur. Okay. So this is already taken. Whatever used to be. These my one's already here. How much ones are already here? Yep, yeah. No. Pen. So, Excuse me, everyone. Everyone who's present here right now who hasn't registered yet, please go register right now itself. Oh, it's out there right now. If you haven't registered yet, please do so.
Should I begin?
A very pleasant morning to everyone. I am Reed Balmiki and I'll be moderating this session. I extend a warm welcome to everyone on the second day of this national conference on developments and trends in corporate laws and governance. I trust that everyone had a restful evening yesterday and is now ready to embark on another day of insightful discussions and paper presentations. After our session yesterday with the enriching discussions that we had, we now reconvene for the second technical session of the national conference. The paper discussions and panel addresses for this session will primarily be based on two themes. The first on insolvency and bankruptcy law, and second on corporate governance in digital ages. Now, without any delay, I would like to invite the panelists for today for this session. I will begin by inviting Shri Ritesh Kavadia, sir, the chairperson for this session. And I request sir to please approach the dais. I also request Sachin Narayan Raju, sir, to present sir with a sampling as a small token from our side. Shri Ritesh Kavadia, sir, is functioning as an executive director in Insolvency and Bankruptcy Board of India since 2018. Earlier, sir has been serving as the IBBI as Chief General Manager since December 2016. Previously, sir has also served as a Deputy General Manager at BSNL. Sir has also completed his Executive Masters of Public Administration from Syracuse University, USA, and has several certificates of advanced studies credited to his name. Sir, we welcome you and we are pleased to have you here with us. Thank you so much. I would now like to invite the panelists for today, and I would begin by inviting Dr. P. Narayan Rao, sir. I also request A. Venkat Subbaraidu, sir, to please honor sir with a sampling. Dr. P. Narayan Rao, sir, is an associate professor with School of Corporate Law and School of Competition Law and Market Regulators at ICCI. He is a nodal officer from ICCIA to Insolvency and Bankruptcy Board of India. Dr. Rao is one of the key persons for bringing the postgraduate insolvency programs at ICCIA. We are grateful to have you here with us today, sir. Thank you. Next, we invite CS Anshul Kumar Jain, sir. I request you to please approach the dais, sir. And I also request Sir Isaac Raj to please present, sir, with a sampling from our end. Anshul Kumar, sir, is a member of the ICSI and an independent director certified with IICA. With over 21 years of experience in corporate laws, SEBI-related matters, information technology, IPOs, and acquisition, he has developed a strong competence in regulatory compliance. We are pleased to have you here with us today, sir. Thank you. Lastly, I would like to invite Advocate Y. Surya Narayan, sir, and I would request Saujanya ma'am to please present, sir, with a sampling. Advocate Surya Narayan, sir, is a corporate law practitioner with rich and diverse experience, hands-on experience in handling a variety of cases of legal complex issues. He has also rendered a wide spectrum of functions and services related to capital markets, corporate law, and insolvency law and statutory. Thank you so much for being here with us today, sir. We are eager to hear from you. I would now like to invite the chairperson for the session to deliver his address, Shri Ritesh Kavadia, sir, if you could please join us.
A very good morning to all of you. And it's really heartening to see such an interest in this emerging law that is Insolvency and Bankruptcy Code. We hope that we got NCLT members as panelists today, but I'm told there's some difficulty, but as one member, Mr. Nandula, will be joining us shortly. Traditionally, people see insolvency as a niche area that only a specialist has to know. But friends, let me tell you, this IBC has changed the landscape, and knowledge of IBC is not optional anymore. If IBC has changed the way we do business, changed the way we enter into contracts, changed the way we see the opportunities. Just a couple of days ago, as an example, Hindu Business Line ran a story that said that beware of insolvency risks. The idea was that if there are some investment opportunities which are too good to be true, you have to be cautious. It gave some examples like one vehicle operator that was asking you to buy electric vehicles and lease it back again to the company. And in lieu, it was offering 14% in lease rentals created every month. Plus, they were taking care of repairs and maintenance. The proposition seems perfectly fine, but the problem it highlighted was, what if this company goes insolvent? The vehicle owners as investors will be terms as operational creditors, and they will even find it difficult to take back the control of the vehicles. So these are the some examples where this insolvency has changed the landscape. Traditionally, we see as per law, companies' lives are unlimited, but studies have shown that companies are have quite short lifespan. 65% of the companies do not last beyond 5 years. Average life of a listed company is around 20 years. So, which is much less than the lifespan of a human. So corporates are mortals, they will close down. And as we go on the path of innovation, competition, this lifespan of companies is only going to reduce. So if we are dealing something in corporate law, we are bound to see insolvencies, we are bound to see companies edging out other companies, and we have to deal with insolvencies. The liabilities of a shareholder of a company are limited, but the liabilities of companies are unlimited. So in a sense, society is bridging the gap between limited liability of shareholders, equity shareholders, and unlimited liabilities of the company. And in lieu, society wants that there has to be some checks and balances on the company, so that this gap is minimized, or you can say the equity management or the equity does not curtail the interest of the other stakeholders, be it employees, be it other creditors, be it other stakeholders who are conducting business with that company. The Insolvency and Bankruptcy Code has put great changes in this corporate governance norms. First of all, the foremost, it has put that the right of a management chosen by equity is not divine. If the company defaults, this management can be taken away from this company. It has provisions for twilight zone, where if a director who ought to have known that the insolvency is imminent, but even then it conducts the business of the corporate debtor that is in a manner that is prejudicial to the interest of the creditors, the action can be taken against that director. It has provisions for reversal of avoidance transactions. If the some transactions are taken to take away the money from the reach of the creditors. Friends, I represent a regulator, Insolvency and Bankruptcy Board of India, and we conduct regulations. We frame regulations for the market. This code works on the principle of market mechanism. The Bankruptcy Law Reform Committee that formulated this code put it in clear terms that no arm of government, be it executive or judiciary, should deal with this problem. This is a market problem, and it should be best dealt with the market. And if we go to economic terms, this a perfect market is a situation where a large number of players, buyers and sellers, they have perfect information symmetry among them, and the cost of transaction is zero or low. So to strengthen the invisible hands of market, what we try is that we translate into insolvency, and we try to maximize the number of resolution applicant or bidders in the liquidation. We try that information asymmetry among the stakeholders is minimum, and we try to reduce the cost of the process. In fact, this if the time taken for conducting a process is also a cost on the corporate data or the process, and we also try to minimize that. All our efforts are in that direction. Whatever we do, whatever regulations we make, we first float it through a discussion paper, and for public comments that is hosted on our website. After that consultation is over, we also put those comments on the website with our comments on them, why we accepted them or why we did not accept them. And I would, in fact, all our regulations that has been notified till date, they also remain open for public comments from April to December every year for full 9 months. So I would take this opportunity and use this forum to request you all to contribute generously to our regulations, comment on those, and help us make better regulations for this code. I will talk this code in last 7 years has achieved great success. We have had 887 resolutions so far, realizing more than 3,19,000 crore rupees for the creditors. And it has caused significant behavioral change among the stakeholders. More than 26,000 cases have been withdrawn even before admission from the fear of insolvency that involved more than 9 lakh crore rupees. Even the RBI report on progress and trends of banking in India, which was released just last week, has mentioned that 43% of the total recovery that the banks had in the year 2023, 22-23 came from insolvency route. And this recovery that we mention is just incidental. The real gain is the saving the life of the corporate debtor, the you can say enterprise capital that is preserved. We conducted a study with the help of IIM Ahmedabad for the companies that got resolved, and we to see how these companies are performing post resolution, and it has came out with significant numbers like sales of those companies increased by 76% in 3 years after resolution. There were 50% rise in employee expenses, 50% increase in assets of the corporate debtor, 130% increase in the capital expenditure by these companies after resolution, and the market capitalization of these companies rose by 3 times. So this is this way, this code has contributed significantly to the economy. You all are, we have many research papers lined up today, and on part of IBBI, we promote research. Our website has quite a generous information, and we also provide some information on request to researchers. In fact, we conducted two international research conferences, first with the collaboration with IIM Ahmedabad and in 2022, and February 23, we conducted with the Association of IIM Bangalore. The third international research conference is scheduled in this city with the International Indian School of Business, Hyderabad, in July 24. The last date for submission of proposal is 15 January. I would urge you all, request that whosoever is interested, please submit your proposal at the earliest for this research conference. If the author agrees, we compile the research papers and publish it as an annual publication every year. So that is a opportunity. Some young professionals are there, so I would inform that we run a postgraduate insolvency program where a young professional with a company secretary or law or CA degree can go through a 24-month course 12-month classroom and 12-month internship and become eligible to an insolvency professional. There are 5 batches of GIP. Till now, 3 batches have completed the course. Some 35 professionals have registered from them. Whosoever wants to appear for the campus, I'm told there are 100% placements. Average package is more than 15 lakh. Highest package, I'm told, was around 35 lakh. To this research, students, I would again intimate that we also run some internship programs round the clock, around the year. Whosoever wants to do internship with us, so we welcome them. The students are asked to prepare a dissertation on the mutually agreed topic. After completion, they get certificate and we pay a small stipend too. With this, I think I would not take long, as you will all be keen to hear to the research papers. Thank you. Thank you for inviting me. Thank you.
So now we'll start with our technical sessions, starting with the theme of corporate governance in a digital age. A general instruction to all paper presenters to adhere to the time limit of 5 minutes, extendable by 2. Thank you. The first presenter for corporate governance in a digital age theme would be Kiran Mai J and CS Pavan Kumar B.
Very good morning, everyone. This is initial research that we started on corporate governance and cyber security. I represent the Institute of Public Enterprise. I am the head of the Center for CG and CSR. With a group of students, we started working on this theme on cyber security, and it's very early stage of the research. I suddenly came across the conference, and I'm very close to Nalsar. We are just neighbors to Nalsar. So I thought this would be a good time for me to hear people and also know more about the cybersecurity and the issues of regulations that are being there. So there's no formal presentation as such, but I would highlight what we are trying to do in this particular working paper that has been initiated to work for. According to the present day research, the annual cost of cyber crimes throughout the globe is projected to reach $10.5 trillion by 2025. Meanwhile, the global information security market is expected to reach around $170.4 billion by 2022, which we have already crossed. It has been found that human mistakes are more responsible for the cyber crimes, which is amounting to around 95% according to the data and statistics. So the various types of cyber problems that the corporates are facing is ransomware attacks, internal threats, source code theft, social engineering attacks, etc. Companies face majority of the crimes which are negatively impacting these organizations, and they are sometimes been leading to insolvency and also to the closure of the companies. Most of the crimes that we see are denials of services attacks, which are very been considered as one of the major attacks for cybercrime. But what is that the industry policy is trying to see to take certain important measures in the present stage? The Industry 4.0 highlights that the issues to build cybersecurity awareness and to protect companies from risk, including driven accountability and shared responsibility, seeing continuous vigilance and investigations whenever it is needed. And they're also trying to work on various important standards which are being available in the present stage. And the various sectors that are being affected by cybersecurity, the first important sector that is actually getting affected is the financial institutions and services, especially the banking and the investment firms that have been the first affected sector across the country. The healthcare sector is the second important sector that is being identified as the sector where the cybercrime rate is very high. The retail sector comes in the third because there is a data breach according to the research that data transparency is too high in the retail sector and the data is consumed by various consumers, and that's how also there is a breach of cyber securities in this particular area. And this information breach is basically through the credit cards and the personal data information that has been shared across the various retail outlets. There is another important area that is the technological area, which is also trying to hold the fourth place, which talks about the intellectual properties and the software coding, which are undergoing a lot of threats, and I think there's a lot of issues that are going in the IT segment in this. And the last but the most important sector where the data is most secure is the government sector. So far it's been rated as the fifth sector, which is taking enough care on the cyber security issues to protect the data of the people. So regulation and cybersecurity are closely related, and while the regulation plays a significant role in improving the cybersecurity by setting standards and requirements for organizations and individuals. These regulations helps the corporates to protect sensitive information and prevent cyber attacks, and minimize the impact of security breach. According to the International Organization for Standardization, which has developed a new number of standards on cybersecurity, including ISO IEC 27001, which outlines requirements for an information security and management system for various enterprises. The legal implications on cyber breach, which is one of the important aspects that is coming up in the present times, are being treated as offense in many countries, and laws have been created, and the legal frameworks are trying to protect the organization. Just coming to Indian scenario, the very important milestones that have come across protecting the cyber data and the data security in India, the IT Act 2000, which was enacted by the Parliament of India and administered by the Indian Computer Emergency Response Team to guide Indian cybersecurity legislation and institution to protect data policies and cyber crimes. There are many more amendments that have come in the Information Technology Act. In 2008, we have got a act which talked about the legal recognition of cyber security for organization, and also protecting private data and information from cyber terrorism and distributed denials of services attacks and phishing, malware, and other identity theft. So there are various policies that have come up in the recent times after 2008. In 2013, we have got a national cyber security policy. And in 2020, the national cyber security strategy has been created. IT rules 2021 has come. And in the present times, we have got regulatory bodies and other bodies which are trying to help the government as well as the various institutions. Just to name few, the Computer Emergency Response Team 2000, the National Critical Information Infrastructure Protection Center, Cyber Security Regulation Appetite Tribunal. So these are the institutes that are acting as regulatory bodies. When we talk about governance, we are talking about mostly the corporate governance, but the role of the risk management committee in the corporate governance has to be enhanced to understand the importance of threats that are being coming through the cyber security. So the role has to be enhanced is one of the observations that has come from the research. And it's important for organizations to secure and safeguard the data to protect the interest of the individuals and corporates as such. Thank you.
Hello. Yes. Now I would like to invite Neeta Reddy Mosali to the stage. Thank you.
Good morning, everybody. Respected dignitaries and my respected dignitaries and my dear professional colleagues, a very good morning, one and all. Warm morning, rather. So I'm Neeta Reddy, practicing company secretary based in Hyderabad. And my topic today for presentation is cyber security and data privacy, the emerging challenges and issues. So I would like to quote an eminent scientist quotation: technological progress is an axe in the arms of pathological criminal. So why is it that so? Like, why is this pessimistic truth is unruly unfolding these days? So the reason is the technological advancement, the rapid technological advancement in terms of Internet of Things or cybersecurity, social media and artificial intelligence. Like to name, the Internet of Things is like the software things which we use, the Fitbits or Apple iWatches, whatever, and the autonomous vehicles, biometrics. So all these are very creative, supportive, no doubt. But at the same time, they carry certain threats and dangers if the user is not well aware. So having said that, the concerns include tracking and profiling as well. So what are the other issues? Data protection. So data is dollar. So usually we term it as data is information, knowledge, but in current trends, data is dollar. So why is it that I'm saying so? Because the data, we need to strike a balance between responsibilities and rights. So it's our responsibility to share our information. At the same time, it's our owner's right. It's our right and duty to see that our data is in rightful hands and it's used for legal purposes. So having said this, for every minute, 80 persons are becoming a victim for cyber crimes. And in 2021, it was approximately 52,000 crimes per lakh population. And by 2023, it is like 65,000 approximately. So we can see the trends, how it is going. So this is the reason we say data protection is important. And then cyber crime in India. So the most common form of cyber crime in India is financial fraud. So it has increased to 153% from 2017 to 2021. And what are the frauds? ATM or online or OTPs and ransomware. This needs to be mentioned. So what is ransomware fraud? Like this is where you cannot access the data in your system until unless you pay up. Like this is a kind of malware or a virus wherein it hacks your system. So what is the present scenario? The dangers, threats, leakages, breaches. So how do we address all this issue? So that is where this comes into the picture. Digital Personal Data Protection Acts 2023. So what are the salient features? We'll have a quick look. So this act is applicable to both online and offline data when offline data is digitalized. And then the act provides for data principles like us who are sharing our information and data fiduciaries like people who are processing or managing our information. So this act also provides for data protection board which acts as an impartial adjudicating authority, and at the same time significant data fiduciaries, like these are independent authorities or people who collaborate with other authorities to manage or control our data. At the same time, this act provides the applications for children. This defines children as under age of 18 years, and the data principals who are aggrieved can approach the data protection board for addressal of their grievances. So what are the emerging issues? So emerging technologies are always fast in advancement than the legal regulations. So that is the reason. What are the reasons slow application of policies and technical issues contribute to this reason? So protection of data privacy, the way forward. So what do we do? How do we encounter this problem? Technology and privacy have a relationship which is very sensitive and which has to be dealt with very diligently. And the artificial intelligence, as we have discussed in the very beginning, the biometrics, artificial intelligence, and the social media have to be tackled in a very sensitive way because they have the tendency of profiling, tracking, and micro-targeting. So here I would like to tell what is micro-targeting. So whatever digital footprints we leave while we do some searching on any search engine, with those digital footprints, they can track our preferences. So I don't know how many of you have are aware these days, like even when you search for something and when you talk something, The next moment you get a pop-up regarding that suggestion. So all that is artificial intelligence. And then finally, I would like to conclude saying that certain countries like European Union and USA have their own regulations, like General Data Protection Regulation and CCFA from USA, like wherein people who want to work in European Union, they have to undergo certain assessment. So it's better we have certain assessments like that when we work even in India. And finally, the onus is not only on government or private fiduciaries. It's even on the person who are using. The onus is on us to be well aware, knowledge, and update ourselves with the privacy and data issues. Thank you.
Thank you, ma'am. Now moving on to an online presentation presented by Ms. Varalakshmi M. and Dr. Sailaja Petika.
Yes, ma'am. Yes, ma'am. Good morning to one and all the chairpersons presented in the seminar, all the dignitaries on the dais are presented over here. Actually, my topic is unlocking potential, the role of artificial intelligence in resolving the corporate decision making. My study speaks about how artificial intelligence is revolvalizationing the business decision techniques or making. AI becomes a key factor in how, ma'am, am I audible? Hello, am I audible, ma'am?
Yes, you're audible, ma'am. Yes, you're
Thank
audible.
you, ma'am. Thank you,
If
ma'am.
you could open
So
your
artificial
camera as well.
intelligence becomes a very key factor in how companies negotiate the complexity of the digital era, because changing the way the executives the plan and making important business decisions. And my study examines that how many facts of artificial intelligence, including how it be improve decision accuracy, optimize our resources allocation, and in the yield of useful insights from the large data sets. And my study emphasizes that how the dynamic of human artificial intelligence cooperation in the business settings are changing. And also artificial intelligence human decision making skills, enabling professionals to rely on the for data driven insights while concentrating on the advanced strategies thinking. And also here the main aspect of the study is that my objectives are to examine conventional methods of decision making, and also how artificial intelligence has transformed decision making process, uh, particularly with attention of improvising, predicting, automated reparative jobs, and also real time decision support system. And also artificial intelligence assists the companies in determining and preparing the plans with regard to their own culture of owning, learning, and adoption techniques. So artificial intelligence, remarkable role in the consciousness created by the humans, which has been playing very changing the cycle of the business dynamics. And also it looks in a continuous challenges faced by the businesses as well as developments of computer based intelligence in the corporate sphere, and substantial impact the artificial intelligence as on a strategy. And the different state of corporate decision making in the present scenario also, the artificial intelligence follows the conventional methods and their other aspects also. And artificial intelligence development in business sphere, which gives in the artificial intelligence origin in business environment. If you date back in the middle of the 20th century, it is first intended to become a subfield of the computer science with goal of creating machines that could mimic human intellect. So data accountability and processing power also been constrained for early applications. And also fundamental ideas which were prepared by the way of further developments in business decision making based on the expert systems were mainly focused in artificial intelligence. And also it is very important turning point of the technology development in the development of the computer vision and natural language processing, that is NLP. We would like to say that it is evaluating, providing the decision makers with additional options. And also artificial intelligence enhances the incorporation of a big data technology, which was embedded enterprises to process, to extract the insights from the erroneous databases. And the impact of the artificial intelligence in corporate decision making is, it is data analysis and processing. The one of the most profound impact of AI in corporate decision making is ability to handle the vast amount of data with speed and precision. So AI algorithm excel in processing structural and unstructured data, which is identifying the patterns and also extracting meaningful insights. And it is data analytical capabilities, empowering decision makers to make informed choice based on comprehensive understanding of market trends, consumer behavior, and also interpersonal operations as a business grapple with the ever-growing volume of data. That's why artificial intelligence provides analytical power to be transformed information into actionable intelligence. Apart from that, it is improvising and predictive analytics, automation of routine tasks and processes, and real-time decision support system, because artificial intelligence facilitates the creation of real-time decision support systems with providing insights to decision making. By continuously monitoring the data streams, artificial systems can be alert organization to emerging trends, potential risks, and opportunities in the real time. So it is also, we can explore that the artificial intelligence impact on the corporate decision making is becomes evident that the interrogation of the AI is not just as a technical advancement, but it is also a paradigm shift how business strategies operate and innovate. And according to the my case study, successful implementation of the AI decision making, examples from various industries like our algorithm trading. Here, financial institution leverage AI algorithm for algorithm trading, enabling the rapid decision making based on the real time market data. And healthcare, even predictive analytics for patient outcomes. Hospitals uses the AI driven predictive analytics to assess the patient risk factors and anticipate potential complication. So this artificial intelligence allows healthcare professional to intervene the proactively improvising patient outcomes and optimizing the resource allocations. Apart from that, in retail commercialization, that is personalized the customer experiences. E-commerce platforms clearly employ artificial intelligence, analyze the customer behavior and preferences by providing the personalized product recommendation, and also targeted marketing businesses enhance the customer satisfaction, increase sales and improvise overall customer retention. So these are the case studies which successfully implemented the AI in commercial decision making. Apart from that, there are quantifiable benefits with regard to business outcomes by enhancing the artificial intelligence, by utilizing the artificial intelligence in the corporate sector. And there are many other factors, overriding challenges and ethical consideration need to be taken into overcoming the mitigation strategies. Because by addressing the privacy and security are concerns, and also fair and transparency in AI algorithm also, one of the we have to having a big challenge. But what to do? What is the future trends and innovations with regard to artificial intelligence? The continued evolution of the artificial intelligence, we need to take into the consideration of natural language process, that is called it is NLP, and exponential growth of AI,
Ma'am, I'm sorry
and
for intervening.
integration quantum
Could you please
computing.
conclude in the next 30 seconds? Your time is up.
Yeah, only
sorry
one
to
moment,
intervene.
ma'am. I will conclude with my conclusion.
Yes, yes,
Only
please
give me
conclude.
one moment.
Thank you.
Thank you. So my conclusion is that there are many exploration of the role of artificial intelligence in revitalizing the corporate decision making, which is enabled critical insights into the transformative potential of AI technology. So we have to cope up with the good laws so that we can control the certain pros and certain cons which we supposed to overcome in the corporate sector. Thank you so much for all the organizers for giving me this good opportunity. Thank you so much, madam.
Now we'll take a small tea break and we'll reconvene in 15 minutes and we'll start with the next technical session on IBC. Thank you. now we would be moving on to the theme Insolvency and Bankruptcy Code. The first speaker for this technical session would be Dr. Preeta S. I would like to invite her to the dais. Dr. Preeta S.
Respected panelists and dear friends, my paper is on cross-border insolvency. Friends, you all know that we live in a globalized world where we have companies operating in different jurisdictions, having assets in different jurisdictions. And when such a company, especially when a multinational company becomes insolvent, you have a whole lot of legal issues cropping up. The main ones include multiplicity of proceedings and also the uncertainty with respect to the substantive insolvency law that is to be applied in the case. And there are also other parallel issues coming up, like which bankruptcy court will have the jurisdiction to deal with the matter, whether the insolvency professional will have access to foreign courts, and which substantive law is to be applied. So all these are the issues. And the legal system has been approaching this issue basically through different approaches. Like you have the universality principle, which says the bankruptcy court of every jurisdiction where the company has an asset shall have the right to commence proceedings. Then you have the territoriality principle, and then you have the unified territoriality principle. And consolidating all these principles, we have the UNCITRAL model law, which follows the unified territoriality principle, wherein you have a main proceeding and parallel proceeding to deal with a cross-border insolvency case. And if you go through the principles, we find that there are four main principles. One is access to foreign courts. So wherein the representative, the insolvency representative, is given access to a foreign court and he is given the right to commence a legal proceeding in a foreign court. So that is with respect to access. Then you have the principle of recognition, wherein one proceeding will be recognized as a main proceeding and the other proceedings happening in other jurisdictions will be considered as non-main proceeding. And for recognizing a proceeding as a main proceeding, we have the concept of COMI, that is the center of main interest. And the UNCITRAL provides for a presumption of COMI in the place or in the jurisdiction where the company has incorporated. Well, this is a rebuttable presumption. And if evidence is produced to the contrary, some other proceedings can also be recognized as a main proceeding. And the proceedings happening in other jurisdictions will be recognized as non-main proceedings. So that is a second principle. And the third principle is the principle of cooperation, wherein the respective courts will be cooperating with each other with respect to the information that is to be shared, the communications that are to be made to the respective parties. So there is a detailed framework as to how the communication is to happen. And finally, the last principle is the principle of coordination, wherein the parallel proceedings will be in line with the main proceeding so as to avoid any kind of inconsistency in the kind of orders that are being issued. So these are the four principles that are found in the UNCITRAL model law. That is the principle of access, the principle of recognition, the principle of coordination, and the principle of cooperation. These are the four principles. And the Insolvency Law Committee recommended that the ancestral model law should be adopted in India because the Insolvency and Bankruptcy Code did not have specific provisions. We have two provisions, but that was not found adequate to deal with the cross-border insolvency cases. So in line with the recommendations of the committee, we proposed Part Z, which is to be added to the code, Insolvency and Bankruptcy Code. And I've gone through the provisions and found that most of the principles that are provided in the ancestral is being incorporated in the Part Z also. So Part Z provides that the IBC shall apply to cases where assistance is sought by a foreign representative to access the Indian courts, that is the company law tribunals, for getting reliefs. And also this code shall apply, the Part Z shall apply to proceedings initiated by Indian representatives in foreign courts. And also the provisions with respect to cooperation, the provisions with respect to coordination, all these have been provided for in Part Z. We can see that Part Z is very well in compliance with the ancestral principles. So, but when it comes to the practical problems, we find that the procedural niceties have been taken care of, but still we have issues with respect to the framework or with respect to the substantive law that is going to be applied. So when I went through the case laws, I found that we have been facing many issues. One case is Ashapura Mine Gem case, and you all may be knowing about the Jet Airways case also, wherein there was a lot of complications, and finally we came up with a protocol, and then finally the matter got settled. So it is very important for us to build a robust framework, a time-bound framework, so that we can protect the foreign creditors' interests and also the interests of the Indian creditors over the assets which are lying in foreign jurisdictions. And it is very important to assure India's position as an investment destination, because if you don't have a framework for timely settlement of the matter, that can diminish the position of India as an investment destination. So I think we all should work forward, particularly the regulators are taking a lot of initiatives in this regard, and I hope in due course we will have a proper framework to settle all the matters in a timely manner. Thank you.
Now I would like to call upon Mr. Rakesh Chandra Sharma to present the paper.
Good morning to all, respected dignitaries and the participants. Thank you, Nalsar and the ICSI team for giving me this opportunity to share my views on the topic, sustainable turnout, redefining debt resolution to the India's IBC evolution. Basically, this assessment, I have taken a view from one of the news article published in the Mint newspaper, which highlighted this view, how we can connect this sustainability with the debt resolutions plan, which is embedded in the IBC code. So moving towards this ESG principles integration in the IBC code, I like to highlight in the current landscape, the utilization of IBC is primarily steered by the financial creditors and the operational creditors. These are the two major creditors who are focusing to recover their debts through this IBC mechanism. But at the same point of time, it has been witnessed the major stakeholders shaping the destiny of business undergoing IBC, this insolvency proceedings. These entities held substantial influence in determining the trajectory of the debt resolution plans. And after going through that article and the news which is going on in the recent past, the traditional approach under the IBC has been inherently focused on a narrow spectrum of financial and legal considerations. Now that landscape has been changed. Earlier, we are focusing on the finance and the legal considerations. Now, how the question is arises how how ESG integration can be embed in this IBC code. So there is a lot of discussion going on there. And with this forum, I being a company secretary and the ESG professional, I'm in favoring that this act should be amended, especially section 30, subsection 2, where this resolution plan is moved. So let's come to the next on this, the proposed changes, which is basically considering this recent development. Insolvency regulator IBBI is advocating, as I mentioned, for legal amendment, mandating this explicit consideration of ESG during this evaluation of resolution plans for these stressed firms. And one of the on this form, I urge that whatever principle IBBI will make for this integration of ESG in the resolution plan, that it should define a clear-cut vision, so that it should be depend on case-to-case basis, because every industry is a different business parameters. It should be based on case-to-case basis, not all size fit. So, and I strongly support for this thought, encouraging voluntary commitment by the corporate debtors, because it is a company which is under IBC and on a ventilator, that there are two professionals who are basically indulged in this, the registered valuers and the IP professionals. So they have the full authority to evaluate the resolution plan on a ESG parameters. Of course, they need expert knowledge in this field, how they will interconnect the things with the sustainability to this resolution plan. On the other side, the financial creditors and the operational creditors, they are regularly focusing for their recovery. And as the IBC has a time limit to recover that money, that is a mechanism. It is very difficult at the same point of time to how we will integrate and how we will recover the money from them in a sustainable manner. Because a businessman has a mindset to recover a money from this business profit. But due to some reason, it has been very difficult to manage this business. Now it comes to this IBC. So now, if a person who will perceive that, yes, my business has already gone, so IP professional, if they assume this responsibility towards this social and the environment, the resolution plan can be made in such a way so that if it is viable, then make it sensible for the environmental and the social considerations. It is especially I would like to highlight for an industry which is running and doing good, but due to some supply chain disruption, the Big Bazaar, if you heard the name, that company has been gone. But it is on a ground level, it is totally connected socially. It is very connected to every person. Most of the person has visited to the Big Bazaar in their life. But now it has gone due to this corona pandemic. So this is the biggest example. This is a supply chain disruption, the cash flow deficit, that company goes into liquidation. So that is the main consideration, big example. That company can be under the resolution plan, that can be viable with this thought. And to share the PPT, one thing I want to highlight, PPT. Just a second. I just want to highlight the key advantages of this ESG integration in IBC. There are two basically advantages. One is the ESG integration in IBC will facilitate global recognition. If we do this, it will make viable for this India. The whole world will see, okay, this is the mechanism embedded in the IBC provisions that can be achieved through this step. And then it will be a major contributor towards the India's climate commitments. As of now, if we see India is liable for 6.67 of global emissions. So this is the big mindset of the government here to highlight that India is right now at this stage, and in the next, we have some goals. One is this long-term strategy with the qualified long-term emission goal, net zero emission by 2070. So we need to focus that how we will achieve this, how we can integrate with this this ESG integration in this resolution plan. So we have some challenges as well. I would like to highlight in one line only. The challenges is at first is the regulatory hurdles, which we can deliberate, and the need for industry-wise consensus, and the development of standardized framework for accessing sustainability in data resolution. So I leave it for all the professionals and this such kind of firm, IVBI, IR Institute, all the big eminent professionals to deliberate on this thought whether this resolution plan can be integrated with the ESG principles or not. So this is my submission. Thank you.
Thank you, sir. Now moving on to Miss Ashita Mathur.
I apologize for the delay. There's some issues with the presentation. My name is Ashita Mathur, and I will be presenting a research paper entitled The Saccharine Sweet Reality of India's Sugar Industry, an analysis of Bajaj Hindustan Sugar's debt predicament. So before we start, I would like to take a look at the title itself. What does debt exactly mean in this scenario? Who is this debt owed to? We are all aware of the fact that last year, the SBI approached the NCLT to initiate Section 7 proceedings against BHSL. And we have the presentation up as well. Right. Thank you. So in the year 2022, the SBI initiated these proceedings against BHSL, and shortly the debt had been claimed to have been paid entirely by the company, and later they withdrew the proceedings. However, there was one creditor of note in this instance who had filed for impleadment in the matter as well, who had went relatively unnoticed. And when we look at that creditor, let's first examine who is a creditor. What image does come to mind when we think of a creditor? And there was an organization by the name of Agragami Kisan Samiti that had filed for impleadment. It is a farmers' union from the state of Uttar Pradesh, which is comprised primarily of sugarcane farmers. So in the present instance, the sugarcane farmers of Uttar Pradesh claim a default on a debt of upwards of 2,000 crores from the company. The exact amount of this debt is not clear at the moment, as their impletement application did not contain a figure. However, many news reports have estimated it to be nearing an amount of 2,800 crores. And in this matter, I think it is a fact that had gone relatively unreported, because many had not taken note of the fact that when SBI approached the NCLT, for a period of more than 2 or 3 months, there had been sit-on protests in front of BHSL sugar mills in the state. All of them complaining of a debt that had been unpaid. Under the IBC, when it had recently come into force, many people had claimed it to be a sort of haven for farmers in the fresh start process. There were many suggestions on treating farmers as debtors. However, the position of farmers as creditors has not really been in limelight, except for now. I believe it is a matter that requires more consideration. There does exist precedent for farmers farmers approaching the NCLAT in one instance in the case of New Falton Sugar Works Limited, in which the farmers had been agreed to have been paid 100% of the entire debt. There had been no haircut that they had been offered. The financial creditors took it upon themselves to pay them back their debt. And I believe this is a precedent that should be followed, considering the vulnerable position of the farmers. Additionally, in the case of P. Ayakanu, the Madras High Court had said that it is the state's responsibility to ensure repayment of debts. There had been some issues with the resolution professional in this case, wherein the farmers had claimed that the resolution professional did not take appropriate measures to ensure they had consensus of the farmers. The professional had in fact traveled from village to village, conducted voting in each village, and then presented the resolution plan to them, and only 10% of the farmers had agreed. However, they complained that despite having such a small amount of approval for the plan, the professional had presented it as if it had had 100% approval for them. Obviously, being very aggrieved in this instance, the farmers themselves have been pushing for being recognized as priority creditors under the code, and they believe it would be an apt comparison for them to be treated in the same way as home buyers had been. They wish to be treated as financial creditors, which is a claim that is, it may be offered for consideration. However, obviously the situation between them and home buyers does contain a vast difference. And their claim of being treated as a unique class of creditors may be considered. It may be taken on a case-to-case basis. If there is an instance where a sugar mill is under insolvency, it may be considered to prioritize them, to take note of their vulnerable status, to take note that in actually one case before the Supreme Court in 2014, the court had noted that if farmers are not repaid, they commit suicide. Even in the case of P. Ayakanu, when the company had become insolvent, when the mill was not able to repay debts, many farmers unfortunately did take their own lives because they believed that they would never be repaid at all. And because of this instance, the long drawn process under the IBC does provide a hindrance to their well-being as well. There are certain drawbacks as well to the proposed solutions that they have put forth. For example, right now their claim would mostly be of pure recovery rather than resolution, and which goes against the very tenets of the IBC, obviously. And if they were to approach the NCLT on their own merit as operational creditors, then the company's ethanol segment, which they have placed all their bets on and which they have hopes for helping them continue, would possibly be placed in jeopardy. Additionally, as seen in the case of P. Ayakanu, the resolution professional had to travel from village to village in an attempt to collate their claims. This would become extremely difficult because being in thousands in number over the state of Uttar Pradesh, there would be immense difficulty in compiling and unifying So as I was speaking there, in the event that farmers are considered priority creditors in instances where sugar mills become insolvent, there might be certain hindrances in unifying their claims, in collecting what they want from the company and their position as currently they are posited as operational creditors, which may lead to a possibility of their interests being sidelined, which is why they had their entire, they had been fighting to be recognized as priority creditors in cases where sugar mills have become insolvent. Additionally, the delays in CIRP may prove as a hindrance to their well-being. And I believe that it is a very tricky subject, obviously, as the position of farmers is one that I believe the government should prioritize, them being a vulnerable segment of the country. And in such instances, it may be considered that they be treated as priority creditors. That brings me to the end of my presentation. Thank you, everybody, for allowing me this forum.
Thank you, ma'am. Now, I would like to call upon Matthew Jacob and Arnab Sarangi to present their paper.
Respected panelists and to all those present here, a warm good afternoon to each and every one of you. My name is Matthew Jacob, and me along with my friend Arnab Sarangi, we are students of the LLM IBL batch here at Nalsar University of Law, have co-authored a paper on settlement agreements under the IBC. However, unfortunately, Arnab will be here with us due to a family emergency, so I'll be presenting and Arnab will join us online. So now, to start with, the IBC is a groundbreaking legislation in India, fundamentally altering how distressed companies undergo resolution processes. Now, our paper looks into a key aspect of insolvency and bankruptcy, that is settled agreements, which is crucial in achieving consensual resolutions between debtors and creditors. We conduct a critical evaluation tackling challenges and effectiveness associated with settled agreements under the IBC, including issues like the inconsistent interpretation of IBC provisions and the consequence of breaching settlement agreements. Furthermore, we also touch upon the evolving landscape of settlement agreements in the wake of the COVID-19 pandemic, with an aim to discern any shifts in the frequency, nature, or success of the settlements during the periods of economic stress. All right. Now, the statutory framework regarding settlement agreements under the IBC is embedded in Section 12E of the Code. Although the IBC does not explicitly enumerate provisions regarding settlement agreements, Section 12A provides a structured way of withdrawal of the CIP application once both the parties, that is the corporate debtors and the financial or operational creditors, have reached an amicable term of settlement. The adjudicating authority plays a crucial role in supervising settlement agreements under the IBC, ensuring that the terms of the agreement are fair and equitable to all parties involved. This framework provides a flexible and efficient mechanism for resolving outstanding debts tailored to the unique circumstances for each case while avoiding the protracted litigation associated with traditional insolvency proceedings. Now, the role of the adjudicating authority, primarily the NCLT in the context of the IBC in India, is crucial in overseeing and facilitating this settlement agreements under the insolvency resolution process. Firstly, when the debtors or creditors propose a settlement agreement under Section 12 of the IBC, the adjudicating authority reviews the application for withdrawal of the insolvency application. The authority ensures that the proposal is bona fide and aligns with the provisions of the IBC. This scrutiny is exemplified in the case of Vaishnav Industries Private Limited versus Horizon Global Limited, wherein the NCLT meticulously assessed this settlement proposal to ensure its compliance with statutory requirements and its fairness to all stakeholders involved. Furthermore, the adjudicating authority oversees the approval process of this by the COC. It ensures that a requisite majority approval from the COC is obtained, typically requiring a 90% majority for settlement agreements. This verification process ensures a broad consensus among the creditors, safeguarding their interests and the integrity of the settlement agreement, as demonstrated in the case of JFE Shoji Steel India Private Limited was Danke Techno Electric Private Limited. In addition to monitoring adherence to legal obligations, the adjudicating authority also plays a protective role, safeguarding the interests of all the parties involved. This supervisory position is essential in ensuring that settlement agreements expedite recovery and provide customized solutions, while also aligning with the statutory thresholds and requirements. Next, settlement agreements have far-reaching impacts on various stakeholders on the CRP under the IBC. These agreements shape the trajectory of distressed companies and influence the outcomes of insolvency proceedings. For creditors, particularly financial and operational creditors, settlement agreements offer the promise of quicker and more certain recoveries, mitigating potential losses that might arise in protracted litigation. The COC, representing the collective interests of creditors, gains the power to negotiate and approve settlements, exerting influence over the resolution plans. Debtors find relief in the flexibility and customization that settlement agreements provide, allowing for tailored solutions to address financial distress and avoid the stigma associated with insolvency. The insolvency professionals engaged in CRP also play a crucial role, steering negotiations and facilitating consensual resolutions, which can enhance the effectiveness and efficiency. Now, the IBC lacks provisions for revival, leading to reliance on the NCLT's inherent jurisdiction as per Section 65B of the IBC and Rule 11 of NCLT rules. Settlement agreements can be a source of conflict or remedy, and their effectiveness in reviving CRP depends on the interpretation of the terms of agreement and the court's discretion. The jurisprudence of restoring CRP after a breach of a settlement agreement has been explored in various cases. In the case of ICICI Bank versus Opto Circuits, the NCLAT allowed the revival of CRP, contrasting with the NCLT's initial rejection. The necessity of seeking court approval for revival is debated in cases like Krishna Garg and IDBI trusteeship, wherein the nature of debt after a settlement breach is discussed. The role of IPs in settlements is crucial in ensuring that the terms of the agreement are fair and equitable to all parties involved. The COC also plays a crucial role in settlement, ensuring that the requisite majority is obtained. The COVID-19 pandemic has had a significant impact on the insolvency and bankruptcy landscape, including the use and effectiveness of settlement agreements under the IBC. The pandemic has created an unprecedented economic stress, leading to a surge in insolvency proceedings and a need for innovative and efficient mechanisms for resolving outstanding debts and settlement agreements. And such settlement agreements have emerged as a crucial tool for achieving consensual relations and avoiding the litigation associated with insolvency proceedings. Now, one of the significant impacts of the pandemic on settlement agreements is the changes in the frequency and nature of settlements. The economic stress caused by the pandemic has led to an increase in the number of settlement agreements as debtors and creditors seek to resolve outstanding debts and avoid the costs and uncertainties of the traditional insolvency proceedings. Now, despite the challenges posed by the pandemic, settlement agreements have proven to be successful in resolving outstanding debts during times of economic stress. The flexibility and customization provided by settlement agreements have allowed parties to reach consensual relations that maximize value for stakeholders and promote a business-friendly environment. Now, a comparative analysis of settlements agreements pre and post COVID-19 reveals that the evolving landscape of these mechanisms that is in the pandemic has highlighted the need for greater flexibility and innovation in the insolvency resolution process, leading to an increased reliance on settlement agreements. Now, the pandemic has underscored the importance of the adjudicating authority in supervising settlement agreements, ensuring that they align with the statutory requirements. Now, in conclusion, we have tried to provide a comprehensive analysis of the critical function that settlement agreements perform within the framework of the IBC. It dives into the regulatory laws, statutory framework, and the effects of settlement agreements on different parties involved in CRP. The paper emphasizes the importance of settlement agreements in explaining recovery, providing customized solutions, and protecting the interests of creditors, debtors, and insolvency experts. It also shed light on the complex dynamics that emerged following a violation of settlement agreements. So that's about it. Thank you.
Now, I would like to take this opportunity to welcome Dr. V.R. Badrinath Garu, Honorable Judicial Member, NCLT Hyderabad Bench, with a round of applause. We welcome you, sir. Thank you for gracing the event with your presence. Moving on to the next paper presenter, Megha Mahesh. I assume she's presenting online. A repeat of instructions for her. The time limit is 5, extendable by 2. We request you to kindly adhere to the time limit strictly. Thank you.
Warm greetings to one all present here. I hope I'm audible and visible. I belong to the LLM batch of Nalsar University, and I sincerely apologize for my inconvenience caused due to the absence of my presence there because of my personal emergencies. So before I begin with, I would like to ensure that my PPT is also visible. Yes. So a very good afternoon to everyone present. My topic would be about the requirement to restructure the corporate insolvency resolution process in terms of the admission of application procedure. So I'll be dealing with section 7, 9, 10, wherein the CIRP procedure has been initiated by the stakeholders, that is by financial creditors, by the corporate debtors, and the operational creditors. So the reason why I've chosen this topic is to understand why such delays have been caused. What is the necessity to curb such delays, and how can they comply with section 12, which is the timeline to complete the entire CRP proceedings within the stipulated period of time, so that the object of IPC, that is to maximize the value of assets or speed is of the essence, that can be achieved. So that being the question in mind, the problem is the reason why the firms or the entities could not comply or could not look into the provisions is because there are practical discrepancies caused. So every time when there is a proceeding begin, it has to ensure that it has to go with the time-bound manner, with being the object of IPC. So to start with, admission procedure for CIRP. If I have to specifically start with section 7, under which they talk about CIRP initiated by the financial creditor, under which section 7 clause 4 specifies about the duty of the adjudicating authority, that is the NCLT, to admit the application or to reject it based on a few factors. One would be to look into the existence of default. For example, if there is a default cause where the debtor has not repaid the creditor, at that time, an application is filed by the creditor to start CIRP. So at that point, the object of the adjudicating authority is to look into the application, see if there is any default, and with that to decide if it has to admit the application or reject it. But then at that 14-day timeline specified in these sections, it in practicality is not implemented in a much better way. The reason I've analyzed through my research are unreasonable in manner, because when I have to deal this issue with a lot of judicial pronouncements which has caused on the same issue. For example, if I have to cite the case of ArcelorMittal versus Satish Kumar Gupta. In this case, Supreme Court held that the word in the section shall be completed is not mandatorily used, because the NCLT is the option to complete the application procedures directory in nature. It is not mandatory. So it may be admitted, may be rejected. So that being in mind can be one of the possible reasons why the delay is caused unreasonably at some point, because the NCLT or the adjudicating authority alone cannot be blamed for this delay. There are a lot of other reasons. For example, the other issue would be if I have to look into the filing procedure by the promoters of the company. Let's say the control over the assets goes from the creditors to the promoters. So the creditors would feel like they lack control over the assets, and then there would be reasons for delays caused in that 14-day timeline just to admit the application. So when it comes to the beginning of CIRP, if there is process of delaying, so there would be a lot of reasons why the procedure cannot be completed within that 180 plus 90-day timeline. So only if we look into it in the beginning stage itself, probably we can try to curb such delays. Apart from that, if I have to interpret the judicial pronouncement given under Surendra Trading Company versus Jugilal Kamalnath, the court observed that the order to be passed by NCLT is directory in nature. Also, the SR Steel case versus Satish Kumar Gupta case specifically mentions about the strict compliance of the 330-day timeline. Meaning, under section 12, it is specified that if so-and-so has completed within 180, when exceptional circumstances come in picture, they can extend to 90 days extra. But then the application itself is taking, as per the research that I've made and through all the other initiatives made by the IBBI itself, it is specified that 14 days can be extended to 100 days or 120 days. There is a lot of delay in the application stage itself. So that being the beginning of such unreasonable delays, we need to look into measures to curb such delays. So one being the reason where there is it's a general notion that NCLT benches are pretty much lower in the country, which is not the only reason, because everybody has a plethora of cases in their bench. So once the judges are expertise to look into the cases, it's not just about the expertise, it's about the time limit. So as soon as they look into the cases in a time-bound manner, the quicker the proceedings can get completed. So through my research, I've come up through suggestions apart from what could be done to curbing such delays. One is, for example, if when the proceeding is brought before the NCLT, at that point, what happens is when the proceeding is submitted, the application is submitted to NCLT, NCLT could a little bit look into the written plea more than the oral arguments at first, because the original intention is to admit the application or to reject the application. So at that point, if they strictly look into the written pleas alone and then decide accordingly, later on they can look into the oral arguments, is what I believe in. This can be done so that they could curb the delays in a better manner. One aspect. Secondly, when the section 7, 9, 10 as specified, mentions about the fact that when the application is filed by the creditors, it has to mention the financial record which is with the information utility, with the financial institution, that there is a default. So when there is a unbeatable proof given by the creditor to the adjudicating authority regarding the information with the information utility, if that is proved, and then that cannot be challenged by any other stakeholders saying there is no default. So once the default which is existing is proved at that beginning stage itself, then delays could be curbed in a much better manner. Also, if I believe through my research, I figured out not just through the lack of better capacity of the tribunals or the resolution professionals, I believe there must be cooperation of the resolution professionals, the creditors, the debtors, and all of them in a time-bound manner.
To intervene,
So that being my
time's up. Could you
suggestions.
please conclude in the next 30 seconds?
Yes. So these being my suggestions, I also would like to draw parallels from outside jurisdictions, wherein I figured out the time period for our Indian insolvency is 180, 330. If I have to look into UK insolvency, US insolvency specifies little liberal extension depending upon their framework. So all that I can understand from the entire process and by comparing our laws with the other law is that even if there is e-filing, even if there is a timeline specified, if they could implement these recommendations in a better manner, probably they could curb these delays. So I would like to conclude by stating that although we have a very consolidated and amazing insolvency law in our country, consolidating all the previous other laws, but still at some point there has been issues with implementing so that delays can be curbed and all that. So if I feel if there is a particular procedure which is being implemented, or if there is in a particular section which strictly mandates for completing this procedure in a time-bound manner, these delays could be curbed in a better way. So if there is issues regarding the time period to like I said, 14-day timeline, and if that is strictly followed, then there will be a smooth and a time efficient resolution process in our country. So even if there are better tribunals, obviously which is existing in our country, even if the promoters are taking up the case and filing the petitions, even if there is a timeline specified in the law, it all depends upon the implementation of the sections. So this could be done to reduce litigation costs, this could be done to maximize the value of the assets, and also speed of the assets. That should be looked into before we complete the insolvency proceedings in CIRP. So that is my research paper. Thank you. Thank you for the opportunity.
Thank you so much, ma'am. Now, I would like to invite Mahima Sharma to the dais.
So a very good afternoon to the chairperson, Dr. V.R. Badrinath Nadola, sir, and our panelists, and everyone. So I'm honored to be here today to present my paper on ADR, that is Alternate Dispute Resolution, a revolutionary approach to the global insolvency process. I would like to thank the organizers of CorpCon 24 for giving me this opportunity to share my research with you all. I hope that my presentation will be informative and engaging. So, my research objective will be to determine whether the ADR dispute resolution mechanism effectively and efficiently deals with insolvency cases. To understand
Snegha, could you please mute yourself?
We'll resume with the last presentation in a bit. The presenter is not ready. In the meanwhile, I would like to invite Dr. Venkat Ramakrishnan. Ma'am, are you here? I'd like to invite Dr. Venkat Ramakrishnan Badrinath. I'd like to invite everyone on the stage circuit, if you could please join us at the dais, and all the panelists as well, if you could just join us at the dais, sir, please. Yes, sir, please. The last presenter is not. Yes, sir. Yes, sir. I'd firstly like to invite Dr. V.R. Badrinath Nandulu. Sir. I'd also request Padmaja ma'am to please honor sir with a sampling. So this is a small token from our side, sir. I'd also like to invite I'd also request Dr. P. Narayan Rao to join us at the dais. I also request CS Anshul Kumar Jain sir to please join us at the dais. I also request Advocate Y. Suryanarayan sir to please join us at the dais. I also request R. Venkatramana sir to please join us at the dais. Thank you. I would like to begin by welcoming Dr. Venkat Ramakrishna Badrinath Nandu, sir. Sir has been appointed. I also welcome Mr. Ritesh Kavadia, sir, to join us at the dais, please. I can proceed if everything's all right. Okay. Thank you so much, sir. As I was saying, Dr. Venkat Ramakrishna Badrinath Nandulu, sir, has been appointed as a judicial member at NCLT Hyderabad bench. Sir is a graduate in commerce from Andhra Loyola College and has a doctorate in law from Andhra University, Visakhapatnam. Sir has previously actively participated in civil, commercial, matrimonial, and arbitration law before various courts, and before joining as the presiding officer, Debt Recovery Tribunal in the year 2016. Sir has also served as additional government pleader for district courts, standing counsel for East Coast Railways, Greater Visakhapatnam Municipal Corporation, and in several other similar significant roles. I now welcome Sir to please address the gathering. Thank you.
A very good morning to all of you. Before I begin, I owe an apology to this house for not being on time. It was on account of some communication gap, which of course was inadvertent. But nevertheless, I'm happy that at least at the middle of this wonderful session, I could join these wonderful presenters and the dignitaries who are all present here today. Well, my role here is very dismal in the sense that I have come here to listen to the presenters who have done a very good job. Of course, I missed a few of them, but from the content that I have noted from few of the submissions made by the speakers here, that's quite interesting. Well, now current trend in IBC or trends in IBC, if we talk about, It's quite positive. It is positive because of various rulings given by Honorable Supreme Court, Honorable NCLAT, and of course, NCLTs. Besides this, there's a very important role that is being played by IBBI, whose Executive Director, Mr. Ritish, is here. And IBBI, as a regulator, has been very effectively monitoring this regulatory process by bringing changes in the law that governs the procedural aspects where the insolvency resolution professionals are involved, and certain rules relating to the adjudication at the level of the tribunal at 3 levels like admission, CARP, and if CARP fails, then in the liquidation stage. So IBBI reforms in the field of this new regime, IBBI, IBC regime. As I said, it's quite important. And there are many notable changes that the IBBI has brought in. One such is that as far as the resolution process, one or two speakers have spoken about it. Hitherto, we had a resolution plan for a sale as a going concern of the total unit of the corporate debtor. And if the expression of interest was to be submitted, it was for the entire unit or en bloc. But today, a change has been brought in by IBBI, where the RFRP, the request for resolution plan, where under expression of interest from the prospective resolution applicants is called for, can contain, rather should contain, a provision where a prospective resolution can submit his plan for the plant and machinery leaving the land, or he can take the land and leave that. Depending upon the nature of that particular unit, the corporate debtors unit, which is under stress, it can. This facilitates a very quick resolution of the corporate debtors insolvency. You know, the essence of IBC is the speed. Of course, the speed is expected from the public and all sections, including IBBI. But I always pose this question to myself, and if permitted to you, the speed, if you take a vehicle, if the vehicle has got the ability to go at 150, considering Indian roads and Indian standards, vehicle's ability is fine, but how the road is, the speed of the vehicle is judged the traffic in which it has to be driven and the road on which it can be driven. So a speed, when we take, like we said, a fast tracking code, so the engine is fast tracked, but the track is old. Can the train move fast? There may be derailment. So it requires overall the infrastructure, right from infrastructure. These things are to be taken up. Nevertheless, within the existing infrastructure, within the existing system, IBBI is doing its best and tribunals are doing it best. And the Honorable Supreme Court and NCLAT are also trying their best to see that that speed, the tempo is maintained. Now coming to the role that we play. Now here I may proudly say, the sale as a going concern during CARP, which is now brought in where a person can go for a part of the unit or of a company of what you call the corporate debtor. We have experimented in Hyderabad Tribunal during liquidation. It was a case of Lanco versus somebody. And in that case, what happened was there was no resolution plan. So the liquidation has been initiated. And in the liquidation, major assets were sold in the sale. What were left were a few vehicles, like tippers, trucks, and all valuing some lakhs of rupees, plus crores of rupees worth receivables. There were no takers. There were 6 sales attempted by the liquidator unsuccessfully. Then that very intelligent lawyer from Chennai, he had moved an application saying, allow us to sell in part of these leftover assets, which was not, a provision was never there in the IBC. It was 2.5 years back, 2 years. So the question then was, very easy for us from the bench is say, how is it maintainable? Because if it is not maintainable, our job is easy. We can say not maintainable. Let the NCLAT and Supreme Court decide whether it is maintainable or not. But we have shown a little more interest in thinking why it is not maintainable. That's how thought. Then I asked the advocate to explain, is there any precedence? Leave alone R, is a single precedence. He said, no, sir, this is the first time. Oh, first time means experiment. Let us not fail in it. We thought that way, the bench. And then we have examined the provisions and then the case law. Then we had the aid in aid of. And then we upheld that and said we allowed the application. We have written a detailed order that was also reported. And ultimately today, the result is that a lot of money has been realized, which if you had struck to the hard and fast rule, probably would not happen. Now, what we are saying is when we are talking about the dynamics, because what the trend, from the brochure that was given to me is that the current trend, the trend is to take it forward. In taking it forward, it's not just the NCLTs or IBBI alone. You, the future lawyers or the practitioners before the NCLT, have to think in that line. The law should, a law that is now giving a very good result, should not stop its pace because of the criticism. There is a lot of criticism as well, despite the fact that the recovery, though it is not the objective of IBC to ensure recovery, the recovery is not up to the expectations. Recovery is low. But nevertheless, the recovery here is the highest. The recovery bodies like tribunals like debt recovery and also under the other Surface Act is less than 20%, whereas we have about 38%. And the resolution time. This is one area where the budding practitioners should bestow their attention. See, the CARP process, which as you know, there are 3 stages. Stage 1 is admission. If we admit, then CARP. And if CARP to be concluded in 180 days, exception is extension. And further extension is again subject to satisfaction of the court. So it is time bound. Then if CARP is not there, then liquidation. Liquidation is also time bound. Why it is time bound? Because the asset value, the maximization of asset value is possible, which is the objective of IBC, only when we do it in a time bound manner. Now the timelines, if you all think that NCLTs are not doing it fast, maybe to some extent we agree, but are you not thinking about the other areas where there are delays? If the delays are in just adjudication, please make a research. I request, because you are all in a master's LLM, no? So a research is also part of it. Just take the factors, take the Hyderabad as a unit, if you can, or the wider yardstick also. Just see the filing and disposal date. see the day, how many days we are taking it, and then say, then count the day. After counting the days, see the procedural formalities, time consumed for it, giving notice, then someone appearing, then taking time for filing a reply. Are we too liberal in it? Are we moderate? Or are we very stringent in timelines? Three options you have. And then after that process, then comes the hearing. We don't have a trial in NCLTs. Say, take there how the lawyers take time, or the company secretaries who are all presenters take. If they take, why are they taking? Okay, they are ready to submit, but we are not ready to hear for some reason. For that reason, for how many days delay is there? And then come to a scientific conclusion instead of randomly just striking at saying NCLTs are delaying, NCLADs are delaying. It's not really so, we tell you. When I'm on the other side, my perception was also more or less same as like. But when I've come to this side, I realized when we wanted to move also, there are opportunities. Someone is talking about principles of natural justice. See, what is innovative ruling, which first opened the Pandora's box for a notice to the corporate debtor? I still feel that judgment requires a revisit. For myself, personally, I'm talking about, nothing to do with any of my impressions. It's only personal impression, that's all. See, I tell you why. Did you notice that before an application under 7 or under 9, when it is filed, a pre-notice to the opposite party is mandatory, which shall be issued by the applicant. A financial creditor will file a copy of that application, that which he is going to file in, will also file an acknowledgement before us that I have served a copy of this on the other side. And if it comes to 9, there is a demand notice also. First, after that, then he will file a petition before us. This copy will also be must be served, first of all. When there is enough time to that other person to go through the record of the complaint. What is the case in a IBC? It is that you owe money, you have defaulted. In case of, let us take a financial creditor, is a financial institution. There is a documentation. All that copies, everything will be available with the other side. Once again, this petitioner reminds him, these are the documents you have executed. So you have not paid. If you had really paid it, come on, he can show it at the first hearing date itself, I have paid. Or he can say it is barred by limitation. He can say some law prohibits. That's all it is. So can we not decide it in 14 days? I still feel, but for the judgment, if not all NCLTs, a few NCLTs at least would have disposed of the matters in 14 days. See, we have to change the thinking. I was a civil lawyer for 30 years. Then when I went to the debt recovery tribunal, I was thinking for a few of 5 years of my service there, like a civil judge and giving time. Then I realized, no, this is a legislation. It took a departure from the civil law, that where you used to have a mortgage suits, preliminary decree, final decree, all that was dispensed with, and we have got a application under 19 of the debt recovery. Cut short the procedure. So I should not think that I am a civil judge, nor a lawyer entering the tribunal should think he's a civil lawyer. And there is no CPC involved. Now, why I'm telling is adopt to the speed. We'll have to. In that way, IBBI is pushing this system with keeping the timelines in the backdrop. So also the Honorable Supreme Court. Then it is giving little pace, but still I always maintain, personally my view is 14 days time is enough to decide. We only say admit or not admit. In the process, we said if it is 7, we'll see, because in innovative industries itself, in para 30, it said debt and default once established, provided there is no interdiction of the debt by law, like limitation, like Section 23 of the Indian Contract Act, object such things, which are legal issues, can't we decide it? At a premier level, we are not talking about a case in a junior civil judge's court or a magistrate's court. When you have created a tribunal, taking away the jurisdiction of a high court and conferring it on it. And then if you still expect that give time, I think she is Kamachi. She said, justice delayed, justice denied. But justice hurried is justice buried. All things are said. But where is a delay? You are giving opportunity, right? Time. When you want to, you find a difference in local train and a metro train. You want to reach early, so you prefer metro train. See, it has the difference. That's how this is a metro train. We'll have to tune it to it. Fare is more. And then allowing time and getting out, all these times are very quickly you should do. All that thing, this is what we are saying. So please think one important aspect in this IBC regime. We'll have to act differently and swiftly. If this legislation is not preserved, I'm afraid we can't expect a better legislation to come in future. It is our duty as the students of this subject. I want you to be more positive on the subject. Suggest all positive things so that the system as well as this law will go in a right direction. Otherwise, well, you know what it is. So the message that I give is we have to do our role properly insofar as this IBC law is concerned. As a member of the bench, the judicial member of Hyderabad bench, we are endeavoring our best. In fact, IBBI ED is also here. It will be very pleasant to know. Yesterday, our Honorable President was here. Today, we don't have a single application seeking for approval of resolution plan pending with us. We cleared all. And we are waiting somebody to file it so that take it up, give opportunity, and then dispose it of. And coming to the admission applications, we have 11 applications only, and which we can finish it off in less than 2 months. If we go by that, most of the lawyers, I think one very prominent lawyer, Mr. Suryanarayana, who is here, he may feel if you all dispose of cases with that speed, probably we will not have some work in that particular area. So these are all the things. See, let us all do our bit to this and preserve this wonderful law. Thank you very much. As I said, I have come here to just listen to a few of the speakers. And one comment, if I have a time, 1 minute. See, one of the speakers, I think Sharma, she was talking about the ADR in IBC. I tell you, see, I made an experiment. I make many experiments and they're failing, of course, but few of them very successful. I tell you why I said experiment. One application under Section 7 came up before me. It was a huge matter and the parties were very, very seriously engaged in their respective contests. I won't use the word fight. Then incidentally, there is an application under 241 of the Companies Act. You know, when the company's acts of operational mismanagement are alleged against the company or its members, then the member aggrieved can move. So these two people, they are also directors and they have a company, and there's another connected dispute. So what happened was they wanted the company matter be sent to mediation for resolution. Well, we have the powers, we have done it. And then this Section 7 also posted to the same day. Then we have asked them, we will send this also. Then we said, no, tribunal has no power. Show, is there any express bar? There is one judgment they have shown by NCLAT. Honorable NCLAT Chennai said, you can't force parties to go. I think Venkateshwar's case. That case, what they did, the tribunal said, while adjourning, if you don't settle by the date, we will pass appropriate order. That means, in a way, it sounded that the tribunal has forced the parties to settle it. So I said, we are not forcing you. We are sending it to the mediation, either individual mediation or institutional mediation. There you can say, sending a matter to mediation is not force. Supposing before a mediator you say, I'm not going to mediate, I'm not going to agree to those terms, then the mediation fails. I thought, why not we experiment? Despite stiff opposition, I have sent it. I have sent it saying, given a reason. Then what happened was, as you know, one party aggrieved financial creditor. He took the stand before Honorable Enclad. Honorable Enclad, again quoting the very same judgment, said, no, NCLT has no power to that Prajai Industries, I think that company name, Prajai, it starts with Prajai. That is the company. There's a respondent. So then Enclad had set aside my order. Then the matter, other side went to Supreme Court. Before the Supreme Court, what Honorable Supreme Court said, it has not entered any finding on the merits, but said that it is not arbitration, ADR, mediation is not provided for Section 7. With that observation, Supreme Court again confirmed the order of NCLAT, thereby set aside my order. But that is not on a detailed merit. So since you are speaking about it, go through that order, make a research. I still want that judgment can be revisited. Today, one more reason also, we have a Mediation Act. I don't know any one of you have touched it or not. Government of India. And recently in our colloquium at Chennai, I was trying to bring that topic in the discussion table. If you read, I think it is section 9 or so in that Mediation Act 2023, a dispute of this nature is also falling. And expressly IBC dispute is not excluded. Why not we think yesterday's situation was yesterday. Today there is a sea change. Any judgment can be revisited. Attempts are made even to revisit Keshwananda Bharati, and you know what ultimately said no. So these are things, such landmark judgments. These are trivial issues, can be revisited. So think of as researchers. There's a very interesting topic, but is there any doorway? If you get that order, we will send half of the matters to them. Where? And then they can be resolved quickly. This is one area. So thank you all for giving me this opportunity. Thank you very much.
Thank you so much, sir, for those insightful words. I would now request C.S. Venkatramana, sir, to present Dr. Badrinath, sir, with a memento as a small token of thanks. Thank you so much, sir. I also request C.S. Venkatramana, sir, to present Shri Ritesh Kavadia, sir, with a memento as a small token of thanks. I also request Mr. Mahadev, sir, to please join at the dais.
Friends, Mr. Ritesh Nalsar has to leave to airport. He is having flight. So please take excuse from me. Thank you, sir. Thank you very much for being here. And
I would now request CS Anshul Kumar Jain sir to please address the gathering.
A very good afternoon to all of you, people on the dais of the dais. And thank you very much, Nalsar University of Law and ICSI for inviting me. And a very unique kind of a program. And usually people like me are not used to such kind of addressing such kind of program. And but interestingly, heard three first presentations on corporate governance and digital age, and subsequently 7 presentations on IBC. Of course, IBC is not my subject, let me admit that. Mr. Ritesh, who just left, talked about the average age of the companies. And he mentioned in his opening remark that in India, the average age of the companies is between 5 years to 20 years. But thankfully, in my career, I've worked with companies who is having the history of 100 years plus, and also one more company having the history of 45 years plus. So, this research, of course, because as a business, we always look for acquisitions. And when we look for the acquisitions, we always do a research on the governance side that why the company's governance system fails. So one interesting conclusions, which was derived actually from the research side, that there are companies who are in the multiple businesses, and so they lies in fashioning a model to address. So the challenge, the biggest challenge in the corporate governance, what happens that we are into the multiple business. So we need to address the uniqueness of each business, because suppose I am into the stockbroking, at the same time I am a mutual fund house, at the same time I am a, say for example, I'm a stockbroker, at the same time I am a PMS service provider. And so every business is a unique characteristics, but as a group, I need to strengthen the unity for the purpose as a company as a whole. Now there is a problem. So if I'll apply the business principle of PMS business on the mutual fund side, so definitely it is not going to work at all. So this is the biggest problem. And the companies who has addressed such kind of issues very well, they are very successful. Notably, I can give the example of ITC, one of the company having 100 years old history. Initially in one business, now in the multiple business, and one of the prominent name in the FMCG. So they have a single corporate governance policy, which is very well available on their website. So, and of course, very good disclosure they made in their annual reports also about the their governance structure and everything. So this is what actually why the company fails in their governance system. Historically, if we look at the corporate governance was connected to the conflict of interest. So originally, when the concept of corporate governance, so we talk about only to address the conflict of interest. Wherever there is a conflict, we should not, we should address that piece. But slowly and gradually, what has happened? The board also started taking interest in the day-to-day processes. And since when the digitalization comes into the picture, then there is a seriously board looks after the entire day-to-day business processes. The more mainly like our presenter talk about the data securities and all, and it's a very important subject. And if you look at the even the amendments in the listing regulations. So listing regulations came into effect in, I think, in the December 2015. And today we are in January 24. It's close to 8 years. In 8 years, if you look at the number of footnotes referring the amendments in one particular regulation or sub-regulation and all, you know how many in the LODR, which you as latest as I checked sometime back, sitting here only, there are 456. So even the because the regulation which is talking too much about the governance is undergoing frequent changes. And in 8 years, there are 456 amendments. This is something crazy. We are not realizing it, but even in last 2-3 years, if we have seen, there are so many amendments, and every time we need to, you know, update our processes and everything. And but as far as digital part is concerned, so let me come to the regulation 21 of LODR regulation, which talks about the risk management committee. Now, when this risk management committee was originally notified, it was a very simple regulation, very simple, that the company should have a risk management committee. It should meet once in a year. It can have a member other than from the board. That these are three I think sub-regulations. Now it talks about much broader. Now it talks about the terms of reference also. And if you look at even the regulation, what it says that the board of directors shall define the roles and responsibility of risk management committee and may delegate monitoring and reviewing of the risk management plan to the committee and such other function as it deem fit. Such functions shall specifically cover cyber security. Now, this is something very important. A specific function is given to the risk management committee on the cyber security. Not only this, it also, now, if you look at the role of the committee, which will be defined by the board. So there is a schedule where there is a terms of reference, suggested terms of reference is given. It says that the framework for identification of internal and external risk specifically faced by the listed entity in particular, including financial, operational, sustainability, information, cyber security risk, or any other risk as may be determined by the committee. So that's the another term, it is falling under the terms of reference also. And that's the primary reason why the board member has started taking the interest in this digital side also. Then come to the BRSR core. Now, you must be knowing that there is a disclosure with regard to the BRSR. The companies are supposed to give every year as part of their annual report. So in BRSR core, there are certain disclosure with regard to the cyber securities also there. Is there any, what is the policy for redressal of grievance related to the cyber securities, number of grievances related to the cyber security, and also it talks about the company policy on the cyber security side. So even that also talks about, and the BRSR core is also applicable to your value chain partners. And one of the questions says that whether the companies are extending their policy to their value chain partners or not. So in totality, if you look at, it's a very wide coverage. It has a very wide coverage. Even the SEBI on various market intermediaries, especially on MIIs, they have mandatorily told to those MIIs to form a committee of the board, which is primarily we called as the ITSC committee, Information Securities Committee. And that committee is a detailed framework SEBI has provided. So that's how even the regulators are trying to give a lot of focus on this. And the first presentation, first presenter, Miss Kiran, I think we heard her. She spoke nicely about the specifically of the vulnerability of the cyber risk on various segments. So she gave a 5 different sectors. It calls the financial services, healthcare, retail, technology, and government. So incidentally, I worked as a chief compliance officer in past of a company which is managing the 70% capital market data of this country. So you can understand if something goes wrong, that the first person who will jump in the Arabian Sea is me only. So it is such a risky, affair to handle. So naturally, the risk is too high over there. I'm the part of the company which is the largest retail, having the largest retail business in the country. So naturally, the lot of risk involved, and our stores are having the footfall. If we consider the India population, so more than half of the Indian population visited our store last in number of footfalls. If I talk about, more than half of the Indian population visited the stores at least once in a year. Whether they shop or not, that is a separate issue, but they visited. So kind of, the data which is going into the system again is too high. And of course, technology risk is there. But the chronology which she presented, I am not satisfied with that. The chronology, the highest risk, actually, I personally feel start with the government only. Because the reason, if you want to enter into the financial market, what is the first thing you should have? You should have the PAN number linked with Aadhaar. Where is that? It is with government. If you want to healthcare, where is your all vaccination data? It is with government. Linked with Aadhaar, again the government. Even your healthcare schemes, the Ayushman scheme, even your healthcare insurances, all are linked to your PAN and Aadhaar, again with the government. So lot of data which is so the most riskier the data which is handled by any agency in this country is the government side, and of course they are doing fantastic job in securing a lot of this thing. Ms. Neeta spoke nicely about the cyber security and data privacy. I would like to give one suggestion on her presentation. She mentioned something about, if I understood wrongly, please correct me, but she mentioned about in one of the slide 80 crime per minute on the cyber side. If she's here, I don't. You are. Sorry. But at the same time, the next statistics which talks about the reporting of such crime, the numbers are not gelling with each other. So what may be the what is restraining people to report the cyber crime? That research is also required to be done, because that will create a lot of value in awareness, creating awareness. Because what I have seen with your research paper, my conclusion is that cyber crime is happening. It is happening. I am aware of that. It is happening. But the reporting of cyber crime is not happening to the authorities in the equal number. If it is 80, it should gel somewhere. So might be, my understanding might be wrong, but that research can be done. It could have been, it could add the value to your paper.
Yes, sir. Can I add one more point?
Yeah,
Actually,
please.
I myself had 4 such cybercrime issues, and I didn't report in any one of the issue because I didn't had any financial or other loss. But then my account was hacked, or my profile picture was copied and used by some other person. I got fraudulent calls to share my OTP and all that. But I received 4 such issues. So it could be that way because I didn't report.
Even personally, I also face such kind of issue, and even I am still unsure that what went wrong. And some person, there was 60,000 rupees transfer my bank account to someone else account. But immediately within a few minutes, I reported this matter to the nearest police station. They guided me to do this, do that. And I submitted the requisite applications and some document to the bank. The money was credited back in my account with lien marked on it. And after 1 month of investigation, the lien was also lifted. So I got my money back. So that's how it is. So it was a timely reporting of the matter actually got my money back. So that's how it can be. So that can add the value. That's the only point. And Ms. Varalakshmi, she mentioned about the example. She gave the example of various industries using the AI. She gave the examples like algorithm trading in the capital market. But I would say the best example is the entire financial market itself, or using the technology. And India is now the perhaps only few countries, and I think only country, which is using the T+1 settlement cycle. And those who are from the capital market, because I am from the capital market side, also I've spent half of my career in the capital market. So I still can't believe the way I saw the capital market 20 years back and now. So still I can't believe that how can we do T+2 settlement even? So T+1 was beyond imagination, but it is now worked out very well and very successfully. And now we are thinking about T+0 settlement. We are thinking about the stock market timing from 9 o'clock to 11 p.m. means 14-hour cycle, where there will be two settlements. One is up to 3:30 trade and one settlement after 3:30 trade. So two settlements in single day, that to T+0. And we are also, and we are on the verge of launching the T+0 settlement. And not only this, we are going to be one of the country who is going to bring the UPI kind of a system in the capital market for the shares settlement. So like your payment apps where you just transfer one account to another account. Simply, you can have one app from your Demat account. The share will go using the UPI kind of a system. That's amazing. Technologies and AIs are being used for the capital market. So that's how some of the feedback from my side. Thank you very much for your time.
Thank you so much, sir, for your valuable feedback. I now invite Advocate Y. Suryanarayan, sir, to deliver his address.
So a very pleasant afternoon to the August gathering here. Honorable Judicial Member Shri Badrinath Garu, all the other dignitaries on the dais and off the dais. Well, it is an immense pleasure to talk before all of you. And I thank the organizers for having chosen me as a speaker to share whatever little bit that I know on the subject. I have been tasked with two tasks, in fact, that to speak about IBC, and also I have been given the task to speak on technology, board governance, and procedures. So insofar as the insolvency and bankruptcy code is concerned, well, Honorable Justice Nariman, when he wrote his judgment, he said, borrower's paradise lost. So that is how he begins. So now the regime has moved once a default has occurred and once CARP is initiated against an entity, then it moves from the owner's control to the creditor's control, and then it is a creditor's driven process. Now, as one of the presenters has said that while speed is the essence, and as rightly pointed out by the Honorable Judicial Member, the delays are not occurring only because of the NCLTs or the adjudicating authority procedures. In fact, we can cut down much time if all the participants, be it a resolution applicant, be a professional, be it a financial creditor, be it an operational creditor, if all of us come together and see that we adhere to the timelines. But however, in any system, there is somebody who is aggrieved, somebody who has a vested interest, somebody who wants to protect his interest at any cost. So therefore, even in CARP proceedings, there are multiplicity of litigations, and every day we file interlocutory applications. So first of all, I think there should be a regulation regarding the maintainability or the very locus of a person to file these applications. And as rightly pointed out by the Honorable Judicial Member, we have maybe the vehicle, the car to go on a highway, but I don't think we have the right kind of highways. When it is a bumpy road, there's no point in driving it fast. We know very well as practitioners that the NCLTs are plagued with lack of proper resources. They don't have trained stenographers, and the employees are employed under contract basis. So on a contract, when you are employing somebody on a contract basis, it doesn't attract right kind of skill, maybe right kind of talent, because the job it is on contract basis. And the moment they get a better job, they move to another job. So first of all, I think as stakeholders, all of us should represent to the ministry that there should be some kind of proper infrastructure with proper personnel assisting the justice rendering process there. So that is one of the requirements. And then coming to the role of professionals who practice or who act as resolution professionals in CARP processes. The role is, there are quite a few challenges, of course, quite a few opportunities. Once when I was arguing before Justice Mukhopadhyay, the Honorable Chairperson of NCLAD, he said, Mr. Suryanarayan RP is like Brahma. He creates COC. And resolution applicant is the rescuer. He is like Vishnu. Then I said, my lord, maybe resolution applicant is Vishnu, but resolution professional is like Abhimanyu. Because he is, first of all, after the application is admitted, the suspended board does not part with the information. Employees are asking for salaries. Suppliers are asking for their payments. And IBBI is monitoring the performance with strict timelines. Penalties are being imposed. And then he has to appear before the adjudicating authority and then also present his case. So these are the challenges. The challenges in CARP process mainly for a resolution professional, is to balance the interests of everyone and conduct the process in a fair, transparent, and speedy manner. And he should always be on his toes. It's a huge task, not very easy. In fact, I was listening to the resolution professional of Jet Airways. There was a conference in Singapore where he has addressed as to how challenging it was during the initial days. Because there are employees, there are regulators, there are also the tax departments, who are demanding, everybody putting pressure on the resolution professional, and how he has created a virtual data room and then various interfaces with various stakeholders so that the process can be completed in a time-bound manner. So, in fact, it could be a case study. Same is the case with Bhushan Steel. Same is the case with ArcelorMittal. Satish Kumar Gupta did an commendable job. So, the challenges for the who's practicing before the NCLT is first to advise the clients properly, tell them the law. We file, but still, in spite of that, we keep filing, applications which are per se not maintainable, knowing very well that they are not maintainable, but still, maybe sometimes we try to innovate. maybe try to find a loophole in the law, or maybe, try to carve out a new position of law. But however, unless all the stakeholders are involved, then unless it is done, it is difficult, for the adjudicating authority to see that the process, the resolution happens in a time-bound manner, or the cases are disposed in a time-bound manner. And then coming to the other aspect in today's topic, that challenges in approving the resolution plan. What are the challenges that are faced? I think even though IBBI has taken out a paper, a circular to the financial creditors, saying that the financial creditors who attend the meeting must come prepared and must be in a position to vote then and there itself on the approval of the resolution plan. Time and again, it so happens that in the committee of creditors meeting, they say that we have to send it to the competent authority, and sometimes sending this resolution plan and taking the approval from the multiple layers in their hierarchy, in their corporate echelons, it takes sometimes even a month. And sometimes the resolution plan is filed at the fag end of the CIRP process, maybe on the 329th day or on the 179th day. And then we seek again extensions, exclusions, etc. So everybody involved there in approval of a resolution plan, be it the financial creditors, be it all the members of the COC, must come prepared for the approval of the resolution, for a discussion of the resolution plan, so that these kind of delays can be curbed. And other challenges in the resolution plan are that we as a resolution applicant ask for so many. It is like Hiranyakashipu's wishes. He asks for so many say reliefs, concessions, etc., which some of them may not be sustainable in the eyes of the law, which even the adjudicating authority cannot grant. Of course, once the resolution plan is approved, it is binding on all the stakeholders. But there are some condition precedents that are put in the plan. Even though Honorable Supreme Court in EBIC's judgment has clearly said that there cannot be any condition precedent, but still there are condition precedents that are put in the plan. And then another challenge is there are various other aggrieved parties, say like an unsuccessful resolution applicant, he filing the application to reject the resolution plan. Now, there comes the question of, again, the locus. Of course, if the very CRP process itself is vitiated, they say that we have a locus. But again, there are inclined judgments which say that the only forum where you can go is the Honorable NCLAT. But still, number of applications are filed during the approval process of the resolution plan. So, see, these are some of the areas where the maybe the involvement of the professionals is required and proper advice be given. So, these are just a few thoughts on this, because there is a time constraint. I am not elaborating on much on the IBC because much has already been spoken. Now, coming to the other topic of the technology and board governance and procedures. Well, way back in 1970, Alvin Toffler wrote a book called Future Shock. It was an international bestseller later on. And then he said that how computers would take over the businesses and the way we live. Well, insofar as governance is concerned, technology has crept into every aspect of our life. Now, today, when it comes to board governance, technology helps so much. I remember a seminar in 1998 when there was a seminar conducted by NSDL and SEBI. I mean, speakers were from NSDL and SEBI, where they spoke about scriptless trading. They said dematerialization, you will not have physical shares and you can just transfer the shares without there being any physical share certificate. Unthinkable in 1998. See, we are used, even in stock market, we were used that there should be a share certificate, there should be a share transfer form, giving it to your broker. And then all the company secretaries used to face the challenge of book closure. Section 154, record dates, clause 16 of the listing agreement. So, that time it was unthinkable. Now today, even private limited companies are now mandated to go for dematerialization. So technology has changed the way the corporates are being governed. Now, technology can influence the board composition. It can address the risk management, and it can address the enhanced shareholder and stakeholder participation. Of course, technology has certain, like the speakers today in the morning, the research paper presenters have said that, what are the risks that are involved? But technology can be best used for, say, board composition. You can get best of the board of directors who are apt for that particular industry, and also participation of the members of the board through remote participation, better discussion, better information availability, more participation. Gone are the days where we used to have physical board meetings. Say, it used to be a nightmare to a company secretary to conduct a physical board meeting, especially when there are so many nominee directors. Going to the airport, receiving them, booking the hotels, etc. Now, in the digital age, we are conducting virtual board meetings, circulating minutes through email, getting them approved. Virtually every aspect, whatever, say, section earlier 292 says, all can be discussed at a board meeting, no restrictions. Similar is the case with the shareholders meeting, enhanced shareholders participation, remote voting, to voting through platforms. And now, but the greatest challenge that as the professionals now will face is the enhanced scrutiny by the shareholders. What kind of participation? We have seen that in some of the listed companies, the remuneration, the pay packages of the executives have been voted out. They have been rejected. Special resolutions have been defeated. Appointment of managing director defeated. You have now proxy advisors. Proxy advisors are collecting the data. They are analyzing the data. Your filing of balance sheet in XBRL mode. Digitization of your balance sheet. Everything is in public domain, and data analytics has taken over now. So one cannot be complacent. At the same time, the advantage of the digital age reporting is template reporting. Now we are almost moving to template reporting. What is important is protection of sensitive information and at the same time ensuring disclosure. One thing is you should ensure disclosure. SEBI insider trading regulations or SEBI LODR regulations. Regulation 15 to 27. They mandate so many disclosures in a time-bound manner. And it is all more or less now template driven. And at the same time, protection of, say, the sensitive information and price sensitive information. Data analytics has also provided the company to study the consumer behavior, the consumer patterns, marketing share, etc., which help the board to use the technology. One greatest example of the failure of a corporate, of its board of directors, despite being a technology company, is Nokia. Nokia used to have 70% of the market share, but they slept. The board, they were all technically eminent persons, the board of Nokia. But 2007, January 9th, Apple announced first iPhone. 2007, June 29th, first iPhone was launched. Nokia is out. Now today, if you want to go and buy a mobile phone, and in your list of options, it will be a maybe iPhone or Samsung or maybe OnePlus or whatever. But Nokia is not figuring in your list. At one point of time, it is a market leader. So the technology must be used. After all, technology is available. But technology also must be used for better governance, for enhancing the transparency, for enhancing timely disclosure, because only when there is timely disclosure and transparency and accountability, it will instill the shareholder confidence in the management. So as a board, there is now, say, enhanced responsibility with, say, ESG. My friend has already spoken about the risk management and ESG and regulation 21. And also somebody has spoken about, I think Rakesh has spoken about incorporating in the resolution plan about sustainability. Sustainability, I think maybe Rakesh, in a resolution plan, incorporating about sustainability and say compliances of ESG by a resolution applicant, at this point of time would be difficult. Because first of all, the focus of the resolution applicant is to first, get the corporate debtor and, maybe pay the creditors, for which he has to arrange his own financial resources. But if you also ask him to give his plan, say for next 5 years or next 10 years about ESG, environmental, social governance and sustainability and sustainable practices at a juncture when he is presenting resolution plan, it would be too premature. Maybe once anyway he's taken over the company, it would be mandatory to all the corporates, isn't it? It would be, so to have a specific clause addressing that in the resolution plan, I think would be at this juncture. Maybe we have to travel a bit and become more matured on that aspect. At this juncture, I would find that it would be, say, premature. And then also, we are talking about the risk management. The risk management, of course, my friend Anshul Jain has dealt with the regulation 21, what it was and what it is now of the LODR. The greatest risk that with so much of data being openly available, then there can be data breaches. There can be malware. There can be phishing attacks. There can be also, say, denial of service attacks. Denial of service attacks is where somebody blocks your system and they deny you from providing that service. You are not able to do anything. and also the malwares and cloud security. How secured is your cloud? Cloud security is one aspect which one should pay utmost attention. Remember, despite best governing laws, laws relating to governance, and despite very advanced technology available in the year 2000, we have seen scams like Enron internationally, Enron, WorldCom, and then in India, say starting with Harshit Mehta scam in 1993, say, and then Ketan Parekh scam, CR Bansali scam, Satyam, recent ICICI Bank, NSC, all these, mind you, one common thing in all these is no regulator found out. Everything happened because there was either there was a default or because there was a whistleblower. In WorldCom in US, in Enron in US, it was the whistleblowers. Despite the availability of the best of the technologies with the regulators could not unearth these. All these have happened. For example, Ketan Parekh scam because of the default. Huge default, then it unearthed. So, but now I would say that SEBI has got a very, very robust surveillance mechanism. Now, these days, we don't see many of price manipulation, price rigging, scams that used to happen earlier when it was, say, pre-digital. So now it is for us to adopt these technologies and inculcate, say, proper practices, procedures, and more emphasis on transparent practices and protecting ourselves from all these, say, kind of attacks that we are vulnerable to. So with these, say, words, I would like to conclude. So digital age has arrived. We are in a digital age and we have to deal with it. Now we have reached a point of no return. So we can't again go back to, say, physical trading of shares, or neither can we go back to conducting of shareholders meeting physically only. So we have to move on with by embracing technology and also putting proper safeguards at places, and then also do the corporate risk management. Thank you very much for giving me this opportunity. Thank you.
Thank you so much, sir, for your unique perspective. I'd now like to invite Dr. P. Narayan Rao, sir. Thank you.
So for me, there's nothing left, it seems. So I'll speak about a few aspects when you talk about corporate governance in digital era. I have seen all three papers presented here, and but all are focused morely on that, breaching of privacy, how people will steal the data and all. But before that, we need to understand that how we can digitalize more. Anyway, the technology is there since long. MCA has introduced in 2006. You know that you can do all filings in digitally. Threats are always there, so we are discussing that how we can come out of it in case anything goes wrong. But in spite of saying that, I would like to see more papers on covering how the technology helped for hybrid participation, that is in a digital way. That is one thing which is missing. Second, how we use the technology for market supervision and also for enforcement of corporate governance. See, the MCA, if you see the year that ended for MCA, they have published a PIB, Press Information Bureau. They have given how MCA has performed in the year 2023 ending December. So they have given that what they have achieved. I'll read it out for only 2 minutes. I'll close it. So they are mentioning about the establishment of central processing for accelerated corporate exit. This is called CPACE. This is the Honorable Minister of Finance and Corporate Affairs has announced in the budget speech in 2023 that the CPACE is only exclusive for the purpose of companies which wanted to exit from the group. So they are facilitating, and they have provided how they're facilitating an interface that which you can see from this, that how the central processing unit works to company to exit. So the average time earlier the company to exit in India as for ease of doing business is around 8 to 12 years. Now after IBC, it has been reduced to 180 days. So only IBC gives an exit. That is not enough because you also need to exit from the compliance as well. So how CPACE is useful, they have explained in this document. They also spoke about how they are facilitating annual and extraordinary general meetings, how that time is extended up to September 2024 for the effective participation of all the participants. They're also talking about the adoption of straight-through process STP for additional e-forms, eliminate manual intervention, expediting electronic approval and streamlining operations. They also spoke about how they have facilitated the central processing unit, that is CRC, Central Processing Center, where you do incorporation of companies. For the average time, it used to be, before the CRC has come into picture in 2015, the average time was around 6 to 17 days for a company to get incorporated. But today you can able to incorporate a company with ease in 24 hours. And that is not through e-form, it is through a web form. A web form which has interface for the DIN, a web form which has interface with the PAN number of the company, and also it has interface with ESI, EPF, and it has interface with the bank account, GST number, and everything. So this is there in the process. Most of you are aware since 2015. So that is keep revising. They keep revising. We used to have e-form 27, early INC 27. Now it becomes a SPICE plus. Now the present day what you have, it is a web form. It has interface with the Ministry of Labor. It has interface with Ministry of Income Tax and all these Ministry of Finance and some of the state government institutes also. So the ministry has come very long way to accept the technology for the better corporate governance. And whatever compliances that you are giving, this is basically what you are pushing it to the as a compliance under Section 206 of the Companies Act. Now there is an option to pull over also. So for that, both push and pull over, that we need to introduce a new technology. So the technology in corporate governance, you have to see it in two ways. And this has been well deliberated in recent G20 summit also, that how we can able to introduce the technology for supervision and the technology for regulatory compliances also. So I request all of you to please read the G20 papers, exclusively spoke about how a digitalization can be, the technology can be used in the corporate governance. So that will give a more insight. So considering the time factor, I'm not speaking much because they have a session at 2 o'clock. And thank you so much.
Thank you so much, sir. I now invite CS Venkatramana, sir, to conclude the session. Thank you.
Honorable Justice Dr. Vidyath and other dignitaries on the day. Ladies and gentlemen, we had a thorough marathon session on last 3 hours with the presentations and all. I hope you all have good enriched knowledge. With respect to the NCLT practices, sir, there is a NCLT task force constituted by ICSI, which is sending its detailed ICSI report on NCLT framework in the month of December by our respected president, beloved president. And we are working on several aspects like virtual hearing and the resources, especially the company secretaries who are interns, company secretaries. We are working for as interns in the regional director office and other authorities, ROC and all. So the company secretaries to interns may be to be validated for with the NCLT also. If the trainees are coming to you as NCLT for 3 months, 6 months internship, they will be enlightened and they will know the procedures, and you will have some resource persons also eligible resource persons. We are working on that. And of course, the virtual hearings, the using of the technology, sir, if possible, wherever the summary proceedings are there before the NCLT, if the technology is used on virtual hearings are made for that, especially other than litigation matters, the disposal may be very quicker and timely things will move speedy. This is one of the request suggestion which we can give. And especially on exposure to the professionals. Actually, as Sir said specifically, there are so many limitations with NCLT in disposing the matters. Even Sunarana Sir has told that, the resource there and availability of the infrastructure facilities, availability of members. Apart from that, we, the professionals, had more responsibility to act diligently, advise our clients properly that whether they need to move for the litigation or they can settle out of the court. That is the most important. Instead of probing them to go for the litigation, we can able to give the solution with the mediation other modes. Then the load on the NCLTs may come down definitely. And also whenever we are getting the clients, we have to give the right way of understanding their case facts, and then only we should suggest for going for the litigation. That is the most important thing. And especially the some of the professionals may play the delay tactics where the court time is precious time is wasted. So definitely we the professionals has to play very judicious role and important role, that keeping the in mind the court's time and court's precious time and value. We should time to cooperate with the NCLT and see that the NCLT functions very effectively. With this brief note, friends, we can conclude this session. And I request now Mr. Manjit Bucha to come forward to present memento to Mr. Anshul Jain. Now I request Mr. Karthik of Managing Committee of Hyderabad Chapter to come forward and present memento to Narayan Rao sir. And I also request Mr. Isaac Raj to come forward and present to Surnarayan sir. Friends, tomorrow, Honorable NCLT President Sir is coming. Our President, beloved President Sir also is coming. Vice President Sir is already arriving here. So I request all of you to be there for tomorrow also. There is only one technical session. After that, valedictory session tomorrow. And thank you, everybody. Now you can join for lunch. Already it is delayed. Thank you, one and all. Yeah, afternoon session is there. Level session. Please join for that.
The second session for the day will begin at 2:45 p.m. Thank you. Good afternoon, everyone, and a very warm welcome to the third technical session for the National Conference. I trust that you have been enlightened by the insightful discussions and the valuable presentations that we had thus far. I thank you all for being a part of our transformative journey thus far. As we delve into the third technical session for the day with renewed enthusiasm and energized minds, I request all of you to foster a sense of collaboration and knowledge building as well. The theme for this session is labor laws, Indian Stamp Act, and other revenue laws, and banking, FEMA, and insurance laws as well. Without any delay, I would like to welcome our esteemed chairpersons and panelists to the dais. I request R.K. Sharma, sir, the chairperson for this technical session, to please approach the dais. I also request Mr. Keshav Rao, sir, to present sir with a sampling as a small token from our side. Shri R.K. Sharma, sir, Chief General Manager of IRDIA, boasts over 26 years of experience, holding dual qualifications as Chartered Accountant and Company Secretary, along with IPGDI in General Insurance and Fellowship at Insurance Institute of India. Sir has excelled in key portfolios, including enforcement and compliance, policy holders, and grievance redressal. It's an honor to have you here with us today, sir. Thank you so much. I now invite the panelists for this session. I first request Sri Radhe Krishna Murthy, sir, who is a practicing advocate, to please approach the dais. I also request Mr. Keshav Rao, sir, to present sir with sampling. Sri Radhe Krishna, sir, is a practicing advocate in the High Court of Telangana and Andhra Pradesh, both in the original and appellate jurisdiction, and is also a corporate legal consultant and advisor since 1987. He holds majority of his practice in the areas of industrial and labor laws and has a core competency in labor and employment laws with strategic IR and HR management. Sir has also been a former member of Andhra Pradesh Minimum Wages Board Rationalization Committee representing employees. So thank you for being here with us today, sir. Thank you so much. I next would like to invite to the dais Shri Nurul Hasan, sir, and I request Keshav Rao, sir, to present sir with sampling as well. Shri Nurul Hasan, sir, is a partner at Lakshmi Kumaran and Sridharan and heads the corporate and commercial laws practice of the Hyderabad branch. Sir has worked on complex M&A, joint ventures, and PEVC transactions. He has led several corporate transactions and handles the structuring, due diligence, documentation, and negotiations. Thank you for being with us here today, sir. Thank you so much. Lastly, I would like to request Shri R.K. Sharma, sir. I would like to request, I'm so sorry. Lastly, I would like to request Mr. Samant Ashok Kumar, sir, to join us at the dais. I also request Mr. Keshav Rao, sir, to present sir with a sampling. Mr. Ashok Kumar, sir, has established the Samant Labour Law Solutions after having been retired as the Deputy Commissioner at Labour in 2013 after 31 years of service in Labour Department of the erstwhile state of Andhra Pradesh. He served in various capacities during his tenure in the Labour Department as a quasi-judicial authority, conciliation officer under the Industrial Disputes Act 1947, a registrar of trade unions, and an enforcement officer under prominent central and state labour enactments. Thank you so much for being here with us today, sir. I would now like to invite Mr. R.K. Sharma, sir, to address the gathering.
Good afternoon, ladies and gentlemen. My dear participants, I am going to present to you a personality that is very well known to all of you. He is the Vice President, Narasimhan sir. So please welcome Vice President ICSI. Sir, we are indeed blessed by your presence.
रुकावट के लिए खेद है।
नहीं, it's okay, sir.
Professor. It's okay, sir. No, it is not required, sir. So once again, good afternoon, ladies and gentlemen. And I would like to thank first ICSI and Nalsar University for inviting me to this program. And I would like to cover the topic which is given, is whether the board composition is going to impact the performance of the banks or that way for any other insurance company or be it any other company. So before coming to this topic, I would like to emphasize the background that why corporate governance is needed, more particularly in the financial institutions. We all know financial institutions not only do their business, but they are also dealing with the public money. So it is more important, or it is utmost important that, okay, apart from the normal governance, which is applicable to another company, in addition to that, there should be some stringent requirement which a company needs to comply, which a financial institution, be it say insurance company, be it say banking company, they need to comply, so that the money what they have got it with them, that should be safeguarded. And it should be available to the depositors, it should be available to the insured at the time of need. And because I work in IRDA, so I would like to more cover about the insurance companies. We all know, friends, in case of insurance company and more particularly for life insurance companies, people will pay money in form of premium, and that premium will be paid in some case 5 years, in some cases it may go up to say 20 years also. And that money is paid with a promise that whenever there will be some contingency which has been stated in the policy document, that will happen. So that time insurance company will come up front and they will comply with their promise. They will meet their promise. So in another way, they will pay the claims, what has been stated in the policy. So for that long period, the insured is only paying premium with a hope that whatever the promise which has been made by the insurance company, that will be made, that will be complied at the time of contingency. So in light of this, the role of regulator or role of governance is very essential here, because then you have to really see that company affairs are conducted in such a manner that company remains solvent, plus also they are not doing such a business which will have some say mis-selling issue, which will have some say market conduct related issues. So for that one, in case of insurance company, apart from the normal committee like say audit committee and RMC, risk management committee and all these things, there are two important committee which has been constituted for insurance sector, and that is, one is the investment committee. So investment committee is a board level committee will be there, and there will be some say independent director requirement is there which has to be complied, and the chairman of the company, chairman of that committee should be well versed and should have say required knowledge of the finance, investment and all these things. Why this committee is needed? Because they are getting that fund, and there is a mandate which is given in the regulation that how that fund which has been received from the policy holder or for that shareholder fund has to be invested. So that has to be ensured, that has to be complied, and of course board cannot devote so much time. So there will be some say investment policy which will be broadly defined or broadly laid down by the board. But apart from that, when that implementation of that policy, ensuring that, okay, all the sectoral norms, investing company norms, everything is complied, that responsibility is mainly casted on the investment committee. This committee meets on a quarterly basis, and they will see that whatever the norm which has been specified in the regulation, that has been complied with either by the company. In case there is some deviation, then how that will be dealt with and how that has to be brought to the notice of the board or to the regulator. All this thing will be done by this company. There is one more important committee which has been laid down. And why it has been laid down? Because if you see the IRDA Act, through this, the regulator has come into picture. In that one, it has been stated that IRDA has been set up mainly for the protection of the interest of the policyholder. So it is essential that this should always be in the focus of the board. For that purpose, a committee called Policyholder Protection Committee has been constituted, and that has been mandated, which is required to have by all the insurance companies there. And again, it is going to be a board level committee, and there will has to be some say independent directors would be there. But apart from that one, a person who should be well versed with the consumer related issues, that he should also be especially invited to this committee. This committee will look into various aspects of the interest of the policyholder, and which includes whether there, how many complaint has come, how much is the unclaimed amount is there, whether company is taking some serious efforts to repay that unclaimed amount which has become, and there are whether the product, what has been designed by the company, whether that is meeting the what you call this one, say, reasonable expectation of the policyholder. So when we say reasonable expectation of the policyholder means after a period of, let us say, some 5 to 6 years, they should get some reasonable return on that one. So this committee has been constituted. And apart from that, there is one more committee there, which again specific to the insurance sector, that is with profit committee. Friends, we all know in case of life insurance company, there is a segment is there which is called with profit or par policy, participating policies. So in that type of policy, what happens, whatever the surplus the company is going to generate on that portfolio, out of this one, 90% will surplus will go to the policyholder and 10% will come to the shareholder. So how this surplus will be distributed among the policyholder and shareholder, for that purpose, this with profit committee has been constituted, and in that one it has been mandated that there has to be some independent actuary who will play an important role, and his basis this or advice only, the board member is required to act. Having said that, now if you see the business of the insurance sector, there is a significant change which is taking place this thing. And this changes has happened only because of the usage of technology. Extensive usage of the technology. Because of this one, there is a significant change in the insurance product or insurance sector is taking place. And technology is not only impacting the product, but it is impacting the entire insurance value chain. When I am saying insurance value chain means starting from the product designing to marketing of the product, servicing of the product, claim settlement, everywhere technology is playing an important part. So if there is a board of directors are there, the old school thought of board of directors are there. So they need to now understand the technology. And if the business has changed, then definitely the governance structure should also change. And it should change so that they can effectively monitor the insurance sector, insurance business there. So for that purpose, now it has become more essential that, okay, board of director, the member of the board, they should know what type of technology the company is using, and basis that one, they should ask a right question. Then only there can be effective monitoring should be there. Having said that, whatsoever may be the board composition, whatsoever may be the qualification of the board member, but if they lack the intent, in that case, the governance structure may not be so effective. So ultimately, it depends upon the intent of the board, and for that one, all the policies and everything has to be put in place. So these are initial remarks from my side. Thank you so much.
Thank you, sir. I now invite to the dais Sri Radhakrishna Murthy, sir, to deliver his address. Thank you.
Good afternoon to all participants. I think post-lunch session is always, you feel a bit sleepy because rest a while after lunch, walk a while after dinner. Are you resting or napping? Okay. It is very tough to handle a post-lunch session because mostly you'd be in sleeping mode. That's what I quite experience. And actually, I was asked to be a panel member. I thought it is a panel discussion. There will be a moderator and who would be leading the panel discussion and I would be answering. And suddenly when I came over here, I got to know that I got to first make a presentation, then it would be followed by panel discussion anyway, whatever it is. I brought a presentation. Can you display them?
Okay. May I know about the participants? Participants are basically the company secretaries, practicing company secretaries, or the research scholars, or the students. Come. Yeah. Okay, that's good. And labor laws. Normally to hear it, just you might be knowing about it is a simple law, may not be complicated and other things. It is only very, very simple and a very limited subject. But when you go into it, it is also a vast subject. Literally to cover the entire subject within the span of an half an hour or 1 hour, it is a Herculean task. The thing is that. Keeping all these things aside, I did address about 3 or 4 sessions for the chartered accountants, practicing chartered accountants, how the labor laws is relevant, what is the scope for the chartered accountants to know about the labor laws. Similarly, the company secretaries, you will be advising the company on various laws, and you would also be responsible for implementation, compliance, statutory compliance as well as due diligence, and labor laws is part of it. And everywhere last 4 years, they have been discussing mostly about the labor codes. The labor codes, we talk a lot, and everywhere it is heard. Everyone is having a curiosity to know what is labor code, everywhere labor code. But of late, what is happening is being proactive is becoming deactive. What I come across is normally someone says last 4 years, it has not seen the light of the day. It is still in the loop line and not in the pipeline. And not yet come into force. Suppose giving much hype to the proposed law, which is yet to be implemented, these are my views, which is yet to be implemented, we of late ignore the present law, which is in force. I always suggest, including my client, someone asked what would be the new labor codes are. About 4 years back, when a draft bill came, I deal with about 40 companies as a legal advisor, advising them on the labor employment matters and very exclusively for the employers. And someone says, sir, my company wants to know, they would like to plan the budget for the next year. What would be the impact on the budget in view of the proposed ensuing labor laws that may come into? This is hypothetical. This question was raised to me by my client way back in the year 2018 or 19 somewhere, when the draft bill is online. Now the central government, both the houses passed the bill, president has given assent, only they got to notify the date of implementation, which is not being notified. And it is last 1 year, it is pending for notification of the implementation of Act. And several states, it is in the concurrent list. As you are well aware, the labor laws is in the concurrent list, neither in the state nor the central. Both state and central as well can amend it. So they are also asked for the draft rules. Rules are for implementation of the Act. Some of the governments have sent their rules, state governments, some of them have not sent. And mostly what is happening is most of the governments wait for the others to draft it so that it would be easy for them. I call it in Telugu lift irrigation scheme. Because some people, they look for it. And if you look into it by and large, more or less it would be the same. Because hardly the mechanism which is got to pay attention and focus on it and has to first hold a series of discussions with the professionals, experts, industries. What are the problems they got to discuss and then frame the rules. It is not something is framed. Because in practical, when we implement it, normally the problem is that labor law is a judgment law, unlike the other laws. At times, the sympathy factor also do take place. Do you agree? Yes, it can be on the notions of the judge and on the provisions of law, and it can be called as equitable justice. Yeah, interpretation normally, when it comes to the interpretation, it is usually interpreted in favor of the labor. In favor of the labor. And I read one article, when the judgment is based on the notions of the judge based on the notions of the judge prevails over justice. If it is on the provisions of law, justice prevails over judge. So in a civil case, if you feel that a particular piece, say for example, this pen is there and it is yours, some X claims that it is his. And if you go to a lawyer, you will be asking, do you have a title over it? That is a receipt to the extent of purchase of this article. If you say that you have a title, you would examine the title document and say, we have chances. But not so in the labor case. But not so in the labor case. Do you like to know entire labor laws, or would like to know the education process of the labor laws? What is your choice? You tell me. So that instead of touching the voluminous subject, let us make my presentation luminous, so that at least somebody will have a takeaway at the end of my presentation. You mean to say that usual some aspects of the labor laws? Otherwise, I always believe in not in the completion of my presentation. I believe in accomplishment of my presentation. At least each one of you will have some takeaway at the end of the session. There are several laws which have been summarized into 4 codes, but everybody thinks that it is easy and made it convenient. Rather to say, if I am permitted to put it, it is more complicated than convenient. Because about 3 years back, I had an occasion to address a session in Mysore Chamber of Commerce at Mysore. And the Regional Labor Commissioner of Central, who was also party and author of this all 4 codes, also incidentally happened to be present over there. He did make a presentation because last 4 years it is going everywhere, labor code like Code. But nothing seen the light of the day till date, to be frank with you. The thing is that now, if any violation, specifically you being the company secretaries and the practicing company secretaries you deal with, am I audible to all and one and all? Because your focus would be mostly. It's okay. Because you are in the compliance part. Normally under the labor laws, people think that because there is a lack of enforcement, full-fledged enforcement authority. As such, many people do think that the labor laws are not applicable. Because whenever the enforcement authority is not in a full-fledged enforcement, people think that they don't feel the presence of the act. The presence of the act is felt because there are several laws. See, for example, I quote you an example of Compulsory Employment Exchange Notification Act. Did you hear anything anywhere, this particular act? But there is a compliance under that act. Non-compliance attracts prosecution. And even in your regular statutory audit be conducted by any of the leading top-notch auditing firms, they will not be looking into it. What they would be focusing in the labor laws is the Industrial Dispute Act, Payment of Bonus Act, Minimum Wages Act, Payment of Wages Act, ESI, EPF, gratuity, so on and so forth. These are the main acts normally used. There is one act by name. I'm just quoting the example where there is a chance of missing the compliance. Because there is every chance of missing slip between cup and lip. There you have to file the returns. The compulsory employment exchange notification is only for the statistical purpose, how many you have employed. You have to file your return showing the employment particulars in your organization for the statistics purpose. And everybody is under impression, good old days when I was quite young, the moment we come out of the university, we used to go to for employment exchange, get ourselves registered because this much private sector was not there. Everybody was looking for the private sector jobs.
public sector and government job, which is normally routed through employment exchange. Initially, there is notion and the myth among the employers that the moment we intimate to the employment exchange, we may have to recruit the people referred by them. It is not so. It is only notification, but not the recruitment. I'm just quoting one example, which normally most of the executing enforcement officials or statutory compliance officials in the corporates do miss it. So when it comes to the, normally when you are in the IT service sector, you will be dealing mostly with the Shops and Establishment Act, Commercial Establishment Act. When you are in the manufacturing and the core sector, you would be dealing with the Factories Act, Industrial Dispute Act, so on and so forth. There will be about the accidents and other things, fatal accidents. Usually in the labor and employment laws, the occupier is responsible. Who should be the occupier? Pardon? Director. Director is a nominee director or appointed director or the director on board or the founder? Pardon? Need not be executive director, he can be any director. He might be executing the things, first he have to be a director, then to be the executive director. Okay? I'm just putting it. And the thing is that the director who is on the board, he is responsible. He is the occupier. Then comes to the manager, who is managing the affairs of the company. He is responsible. And in the new law, labor code, what they said is that for every act, whoever is nominated, whoever is appointed as an occupier shall be responsible for implementation of all the labor laws. Because the employer definition and as well as the occupier definition and the responsible person definition differs in the present acts from one act to the other act. Whereas in the new labor code, they said he should be the founder director. So any violation, what will happen? Because my land friend was also enforcement officer earlier for some time. What will happen? It attracts prosecution. Whom? Director. Owner. Occupier. He is the liable for prosecution. When he is liable for prosecution, when a case is filed, normally the summons are issued. When the summons are issued, if he fails to present, a non-bailable warrant will be issued. Normally, it is happening in the companies where they are not having an eye and the vigilance about the compliance. Be it a HR officer who looks after the labor employment enforcement or a personal officer or whatever name you put it, or the company secretary or whoever. When the summon receives, he might be under the notice period in the exit mode. No, I came across such cases. So when he says, why unnecessarily bring it to the notice and invite the hire of the director, my relieving may get delayed, or the final settlement may be get delayed. Why unnecessarily? He puts in the dust and simply goes away. And ultimately, the summon is served when the court calls the case, the director is not present, he is issued non-bailable warrant. That is why being proactive is important in respect of compliance, not in respect of knowing the law which is going to come. It is yet to be implemented. I am sure in this tenure, it won't be implemented, labor codes. Because round the corner in the month of May, there is the general elections. And maybe in a month or so, there may be election code. So we can only expect post-June 2024, subject to the results, which party comes into power. And the new government also has to settle for some time to introduce the new law. So what I request, my dear friends, not to bother too much about the labor codes. When it comes, you can look into it. Otherwise, you get confused. And another thing what I mean to say is that I was just out of the topic. When I addressed a session in the Mysore, that regional labor central commissioner is a party to that. He said, earlier if the employee got to prosecute the employer for any of the violations, he has to make an application to the labor department, and the labor department alone got locus standi to prosecute the employer. Is it clear? Now, under the new labor code, the employee can directly prosecute the employer. He need not put any application, and otherwise the present practice is they make an application, they take issue a notice, they take a sanction for prosecution, then they file the prosecution. Now what is it? In the new code comes into force, any employee can file a prosecution directly against the employer in the court of law. So the employer, that's what when I asked him, employee, it is possible. It is possible for the employee to file, but it is impossible for the employer to face all these cases, whether he will run around the court or run the company. No, when the employees, I quite understand it happens normally where the employees are unorganized. Where the employees are organized, they are having the unions, they are having the protection. They can easily file a prosecution. In a service sector, in a small office, if the employee goes for prosecution, then the employer may fire him. He will have such apprehension that he may get fired. But that too, even that employee also after leaving the employment, if the final settlement is not done, under the new code, within 3 days, the final settlement has to be done. If the final the F&F settlement is not done within 3 days, he can prosecute. What obligation he will have towards the employer after quitting the employment? The concept is simple. With me or without me, there can't be with me or without being me. So he will not have any obligation. He can go and prosecute. Earlier, he doesn't have right to prosecute. When I asked this regional labor commissioner was also party to that, what did he say is, union leaders are making a complaint that we are making applications to you, you are not initiating the prosecution. We don't have sufficient machinery to initiate prosecution and to govern the court. So instead of that, what we said is that why to take blame on our head? We give directly the powers to them. Good? Appreciate. But similar power is not given to the employer. There are certain commitment violations on the part of the workmen as well. Where such violations on the part of the workmen, on the part of the leaders, the employer do have a right to prosecute. But when it comes to the employer has to make an application to the department, and the labor department alone can prosecute government. He can't directly prosecute. That is the crux of the problem over here. Then I said, why have you not given the equal power? There should be equality. Then he simply said, no employer organization did come forward and make such a representation to us. It is only the trade unions have come forward and make such a representation. Then we gave that. What do you understand by this? Employees are organized, employers are unorganized. Do you agree? We should be organized to agree that point, right? Or agree to disagree? Pardon? Yeah, I know this employers organization. I do address certain of the sessions of the Chamber of Commerce, Confederation of Indian Industry, so on and so forth, and other things. Their focus would be mostly on the GST. My friend would be dealing mostly with that, and the commercial loss, not the labor loss. Anything that comes that impacts or the financial impact, they would be immediately holding a discussion, making a presentation, and submitting their objections to the draft bill, so on and so forth, not on the labor loss. It is mostly a neglected subject, but the thing is that it is also going to be play a vital role. to an industrial development bank. What is the tax, sir? But anyway, even a Supreme Court judgment is a binding, whether it becomes an act or not, where there's the judgment, it is a precedent, and as per the Constitution, it is binding. Now, after the interpretation of definition of industry by His Lordship Justice Krishna here, that is being widely followed, and the courts are following the judgment, and as giving the judgment, everything is an industry, whichever is on the earth and below the sky, that is being brought under the definition of industry and being. And the new labor code earlier, what is happening is under the Payment of Wages Act, only certain set of employees who are drawing wages up to so and so only are covered. Now, under the new wage code, every employee is covered under the act. It is applicable to all the employees, right from the lowest worker, blue collar worker, to the highest director also, if he is a paid director. And there are certain things, normally the problem comes with the ESI, basic wage, which should be the basic wage in respect of payment of ESI. ESI is the gross wage, normally you take it. PF and the bonus you take, normally the gratuity you take the basic wage. Basic wage, they said that the allowances should not cross more than 50%. Normally what is happening in most of the cases, employers do fix 30% basic, 70% allowances. It is the bogie that pulls the engine doesn't pull the bogie. So they have restricted it, they have made it that it should be 50%. Basic should be 50%. Yes, ma'am. Problem in respect of settling the account in full and final, there will be pre-settlement formalities in respect of full and final, because they got to submit an OQ certificate from all financial departments and they are not to pay any amount to the organization. In such event, is it possible for within 3 days to get such clearances from the department and the thing employee might be having to own or whatever may be the application? It does. But the thing is that when you have given a notice, that 1 month notice, 2 month notice, or 3 month notice, he could have then asked him to clear that before the date or the when is the reviewing date. They wish to relieve them. They relieve them that they give for the date of relieving. They will also sit to prepare. But there are relief for them. But they can't be done so far. What if my husband is the personal advice, not the working for? The one who knows the law, you should sit the one who knows the law. Abuse can't be taught the working. It is against the profession. So, why mean to say is the obligation of payment of final settlement starts from the last day of working. Then you are not. And the remaining is kept on working. Then the obligation will not start. The obligation starts the moment it is. But by the same time, you keep it holding, the relieving, but you don't make payment, then that is also a problem. So, because when you are not, the last date is entitled for the salary. Am I right or not? But one should not take a personal score in respect of compliance of law. Otherwise, the prosecution score will increase. You got my point? What is the time given to me now? No, because I should not include the others' time. Other speakers are also there. You just simply when the time is up, nothing wrong. 100%? Yeah, that's what. Because I didn't go by syllabi or subject or the course, it is difficult. These are the some of the points. That is why I always advise the compliance, statutory compliance officials, whoever is in the organization, you should must first make a checklist of various acts and check yourself. Where are you? Where you got to be? What is the difference between where are you and where you got to be? Fill that difference. What are the returns to be filed under various acts? When is the time to file the returns? What are the returns to be filed under the Contract Labor Regulation and Abolition Act, or the Payment of Bonus Act, or the Payment of Gratuity Act? When is the recently I came across a case, I think one of my friends might be here, where they had such experience, and the PF contributions to be paid. 15th is the last day for payment of contributions. On 15th, they wanted to make the payment. The server is not working. When the server is not working, that got through on 16th. The PF Commissioner initiated proceedings under Section 7A of the inquiry and imposed damages and interest for the 1-day delay. Whose problem is it? Problem is with the server. Then ultimately there is a good case to challenge, but the penalty imposed is hardly about some 2,000 or 3,000 rupees. But here the challenge is before the employer whether to contest this case, show it to the enforcement they are wrong. If contesting, what would be the cost? Cost would be 100 times than the penalty. Because they need to pay to the lawyers, they have to go to the court. So if the server is not working, the technical part on the part of the server, how can the employer be responsible for that? It is ridiculous imposing the penalty and interest over such things. There the enforcement might has become right. So I always suggest prevention is better than cure. Being proactive in respect of compliance would avoid complications. I always propagate mitigation of litigation is always best because litigation is a speculation without knowing the destination. These are the principles of my advocacy, which I really meant it. If you are proactive and vigilant about the compliance, you would be able to mitigate the litigation. Otherwise, you would be landing into a litigation. The litigation is a speculation without the destination. That is the order of the day. One has to admit, better to be proactive. Know first what is the complaints. Nowadays, everything available online. You can check it. Online also guides, also misguides. I see today there are several WhatsApp groups. Some junior person puts a query, some senior person answers, but the answer is irrelevant. Not just right answer to that. The junior person simply gets carried away. Like there is a word called as hearsay evidence. Here the hearsay knowledge. No one got the patience to open the book, read the provision, try to understand, try to interpret, try to analyze. Simply think because the technology is improved, they simply put it in the WhatsApp and somebody would be sharing. And whether it is the knowledge, we don't know. I come across several wrong advices in the WhatsApp groups nowadays. And they get carried away. When finally landing, they go to a lawyer. They ask, the lawyer says, this is what? So the company said like that. Say that WhatsApp university. When WhatsApp university, you are always student and they became a professor over there. Why do company again ask? And there are, we come across certain employers, the clients, they put a query to us. And when we say this is the law, they again repeat it because they want the opinion according to their perception, not according to law. What can we do? A professional lawyer won't give it. This is what law, you must complain. Again, if he continuously gets the opinion according to his perception, he will be putting on the person after the person. What is that he wants? Whether he wants an opinion, whether he wants to give his opinion time and again. So when somebody says, when you ask something about the law, examine the issue, because I always tell management is nothing but a common sense. Common sense is most uncommon. Law is nothing but a logic. Just think logically, not that the perception to save something. You would be thinking that you would be saving finally landing in a prosecution. So, because my time is up, I have taken the time of others. With this, I conclude. If you have any queries, you can ask after the presentation of the other fellow learned member over. Right? We'll have that.
Thank you so much for your insightful remarks, sir. Thank you. I now invite to the dais Shri Nurul Hassan, sir, to deliver his address.
Good afternoon, everyone. So to coming back from the litigation is a speculation without knowing the destination to the BFSI, the banking, FEMA and insurance laws. Firstly, I would like to thank Nalsar and ICSI for giving me the platform and opportunity to interact with all of you. People usually like stories. I would also like to start with a short story, maybe as an anecdotal reference. So once there is a gentleman who has a problem with his shoe or chappal. So he went to the cobbler, and at the cobbler's place, you will find there is a triangular board which says on one angle quality, second angle price, and third angle time. And it says in the middle, you choose any two, not all three will be available to you. So you choose quality and time, price will be high. You choose price and time, quality may be low. You choose quality, time, price may be higher or so. So you in a services sector, when we talk about service sector as such, particularly the BFSI, which has received in the year 2023 the highest amount of FDI, banking, financial services, and insurance sector as such has received the highest amount of foreign direct investment in equity in the equity inflows in the last year. Even though the topic is banking, FEMA, and insurance laws, I'm actually stretching a little bit to include banking, financial services in between instead of FEMA, and also the insurance laws attached to it. So the year gone by, in the 2023, the year gone by has left some indelible marks, if I may say so, in terms of the population, that the country has surpassed the population and surpassed China and became the world highest populous country. And also, two things which India has evolved very well. One is a smartphone, and the second one is the packaged drinking water. Packaged drinking water and smartphones have been, India has embraced them so well into their lives that one of them is playing a pivotal role in the BFSI sector as well. India has got largest consumer base or second largest consumer base once only after China. And thanks to the internet penetration, internet and smartphone penetration, India is again second in the smartphone usage as such. And the year gone by again has witnessed highest number of UPI transactions. Around 10 billion UPI transactions have been undertaken until October itself. What is this has got to do with the BFSI sector? It has a lot of implications with when it comes to the banking, finance, and the insurance sector is concerned, because BFSI sector or banking sector as such is the gives the economic stability, much needed economic stability to the economy, and also gives a lot of scope for the recovery and growth as such for the economy. Now, recently, the Prime Minister Narendra Modi has also suggested that by 2047, India will become Viksit Bharat, the developed nation by 2047. Now from 2022 to 2047, for a period of 25 years, we are having Amrit Kal, and this 30 trillion economy which we have kept for ourselves an ambitious target is going to be achieved through the modes of GAN, where G stands for Garib, Y stands for youth, and A for Annadata, and N for Nari Shakti. So how we are going to achieve and what kind of role BFSI sector is going to play in this has a lot of BFSI sector as such has got a lot to be contributing to. And as I told you, BFSI sector as such is contributing around 10.4% to the overall Indian economy as such. And coupled with that, BFSI sector is also, particularly banking sector, is also working along with the fintech companies to generate more and more financial inclusion and penetration in the market as such. Even though the foreign investments for the quarter ending June, for the quarter ending September, the second quarter has reduced because of the global slowdown and also the press note 3 issues. But India still feels that because of China plus one strategy, where China plus one strategy is nothing but you diversify the supply chain, you diversify the production aspects beyond China. So far, the Western countries have only concentrated in Chinese for setting up their manufacturing setup. So now China plus one strategy is going to give a lot of impetus to India as such for setting up of more manufacturing units and also receiving more FDI as such. So the foreign investments are also going to grow in the future, in the near future as such. So that's the strategy even India is having as of now. Now the insurance penetration, when it comes to the insurance part, the insurance penetration on the life and non-life is also very encouraging. The non-life stood at 16%, and the life stood at 18% growth over the previous years. The insurance penetration has also been very good in terms of life, both life and non-life. Insurance penetration at life stood at 3% and non-life stood at 1%. So overall, the insurance sector, even though the traditional way of distribution channels, like the traditional brokers, traditional insurance agents, have still been dominant in procuring the insurance business, but still the distribution, digital distribution channels like web aggregators, like Policy Bazaar and other things, are also growing to actually grow in terms of getting the insurance market and penetrate more insurance business as such. So this is the stage where we are when it comes to the regulators as such. Now, with reference to the regulatory environment in the banking, financial services and insurance sector is concerned, how they are moving, how they are strategizing, how they are behaving to these new technological developments, new processes, is that I would list down. I think I have listed down some 4 or 5 methods through which they have kind of overcome the technological advancements as such. Firstly, they have newer processes like regulatory sandboxes. Now, of late, our chairperson to the panel, Mr. Sharma, also can vouch for that. That insurance IRDAI had also brought out the IRDAI regulatory sandboxes regulations sometime in 2019, whereby the innovation and newer novice options and services are going to be tested over a controlled environment with certain kinds of relaxations given to the companies so that the innovation can be developed, and at the same time you will have newer things to take place in the sector. Now, something similar to that has also been brought out by SEBI and RBI as well. Now, if you take a clue from this, let us suppose, can MCA also bring out some regulatory sandbox whereby it can also implement some of the newer concepts? Like yesterday, Mr. Pawan Kumar was also mentioning as a suggestion that we have a lot of family-owned companies in the country. So can we think of having a regulatory sandbox for the newer companies where only families are only running the particular company as such? So we can create what we know as the family-owned companies as such. So as of now, we only have dormant companies. We only have small companies to give certain kind of exemptions and relaxations. Can we also extend this by bringing newer concepts like family-owned companies and see whether in terms of regulatory sandbox, will this be enough to support and bring out newer concepts and suggestions? And apart from that, how the regulators are also is in terms of self-regulation. Like for instance, we have mutual funds, where Association of Mutual Funds of India is an association by itself, which is made of the mutual funds. So the AMFI in itself is a self-regulator as far as the mutual funds are concerned. So can we think of these kind of self-regulating bodies to be in place? And in fact, MeitY, Ministry of Electronics and Information Technology, has also brought out some kind of self-regulatory bodies for the new age companies like gaming, which are in gaming. And this is also one good thing, because even the regulator will not come to know how the players are actually performing. So the self-regulating bodies will bring in a lot of accountability and transparency when it comes to the compliances as such. Now, the other model generally the regulators are performing is risk-based. Based upon the risk, the compliances are ensured. For instance, even IRDAI has come up with risk-based supervision over the companies. If the risk is high, the supervision also is going to be high. If the risk is going to be low, the supervision also commensuratingly low when it comes to those companies. And we also have newer concepts from overseas. Like for instance, in Singapore, we have a cooperative compliance mechanism, where Singapore has brought out these kind of newer things. It's an offshoot, I would say, of the regulatory sandbox, whereby the regulator himself will join the hands of the players and see whether they will be in a position to comply with the provisions of the law or not. And they will assist the companies and the players in the market to ensure the compliance. So this is the fourth way in which the regulators can also join the companies and players in the market and see that we have the optimum and the right approach of transparency when it comes to the regulatory environment as such. Now, fifthly, we have in the G20 summit, the theme was one family, one earth, and one future. Can we think of one platform for all the filings across, like for SEBI, MCA, and RBI, where we can even the same or similar information is being sought? Can we have one platform for all the requirements? So can we suggest something like this to the regulators? So these are various ways in which the regulators are, as of now, in the new technological stage, are performing as such. Now, as far as the professionals are concerned, how we are going to cope up and tap the new age requirements as such in the regulatory stage. One, I would tell you what my experience as a corporate counsel on working in the law firm. We would involve even when the company is coming to us with respect to one of the queries, we would try to involve all their departments. Like if the issue is relating to the formation of any IT policy, or bringing out a new product in the company, so we would involve the people from the IT department. We would involve the people from the marketing department. We would be involving people from of course, the legal legal department, and of course, but not least, the finance department. So as a professional, probably we can also think of when newer products are being launched for the involvement of more people into the overall performance and overall success of the product as such. And secondly, we also frame a lot of policies, and even for the new act, the Digital Personal Data Protection Act, my colleagues have been working on various impact assessment reports and also suggesting the regulator as to how the rules have to be framed in certain way. We are also suggesting the rules to various the industry bodies like CIA and NASCAM, where the rules, where we would like to have the rules in a particular way so that the overall compliance can be ensured by the companies. So advising the companies in all these ways advising the companies on more risk, advising the companies on risk-based issues would definitely be helpful. Yes, I think I'm done with that. If you have any questions, we'll be happy to answer them. Thank you.
Thank you so much, sir. I would now like to invite Mr. Samrat Ashok Kumar, sir, to deliver his address.
Good evening, one and all. Started in the afternoon and we came till evening. At the outset, I would thank to Nalsar University and ICSC for giving this opportunity. Since Radhakrishnan gave elaborate lecture on the labor laws, I would like to touch upon what are the compliances and what are the fundamental issues in each enactment instead of giving a lecture. So, labor is a matter in the concurrent list. I hope you understand what is the concurrent list. What is the concurrent list? Who makes laws under concurrent list? Pardon? Most single state. If on a particular subject, state and center makes same law, who prevails? Center prevails. So that is fundamental. Can you name some of the labor laws made by central government? Please. Try to give full name of the act, or else just name it. See, you have been discussing about labor codes. See, labor codes, 4 labor codes are amalgamation of 29 labor enactments. So there are more than 29 labor enactments. And many are made by the central parliament. Kindly name 10 legislations made by parliament. Payment of wages, minimum wages act, payment of bonus act, industrial disputes act, workmen compensation act, no, workmen compensation, maternity benefit act. Settled. Standing orders act. So good. What are state acts? So basically, there are 2 major enactments enacted by the state government. As you rightly said, Shops and Establishments Act. Each state has got its own Shops and Establishments Act. And other is National Festival Holidays Act. Each state has got its own national festival holidays. So each enactment has got certain fundamental issues. Let us take Payment of Gratuity Act. If establishment is covered by Payment of Gratuity Act, how many employees should be there? Minimum how many employees should be there? Ten and above. For bonus, the establishment is 10. See, when one has to file a case under Payment of Wages Act, what is the salary limitation? Does anybody can file a case, or is there a limitation under Payment of Wages Act to file a case? Who is covered by the act? A person, an employee, a workman drawing less than 24,000 is entitled to file a case under Payment of Wages Act. The person who is drawing more than 24,000 cannot file a case under Payment of Wages Act. Minimum wages? Whatever is minimum wage, there is no limitation. If government fixes some minimum wage, so if he is not getting minimum wage, he can file a case. That is it. And bonus act, what is the limit? Salary limit? Correct. Why are you hesitating? 21,000. Do you know anything about trade union acts? How many employees can form a trade union? Minimum is 7, but where an industry is there, 10% of the workmen. If it is an organized industry, it is 10% of the workmen. If it is unorganized, suppose senior workers are there, hamalis are there, gig workers are there, then it should be at least 100. 100 can form a trade union. And I think most of you don't know, even many of people don't know, even employers also can form a union under Trade Union Act. There are associations medical, the pharma industry, there is association, employers association of pharma industry. Most of the employers, they don't form a trade, union under trade union act, only employees form a trade union. See, you come across many trade union activities. MLAs become trade union leader, ministers become trade union leaders, MPs become trade union leaders. Is it permissible? They don't contest. With the name, they will not contest. The unions will be conducted in the election this year. The post, there will be a contest for post. See, normally, the elections are conducted for either president or for office bearers. If election is conducted for only the president, then he can nominate the office bearers of the union. And there, normally the posts are president, general secretary, vice president, general secretary, joint secretary, treasurer, and others. But normally, if a politician is taking place in the union, he will be honorary president. A person who is holding the office of profit cannot hold an executive position of a trade union. So therefore, they safely call it as honorary president. So when it is honor, he is not part of the regular trade union executive member. So therefore, we should not be carried away that since he is president, he has got all the powers and this thing. Suppose in the conciliation meeting, somebody takes objection, he is not allowed to participate in the conciliation proceedings. One can take, third party cannot participate in the conciliation proceedings. So a lot of cases recently happening, MRF, many other companies. Even politicians are presidents, they are not being allowed to participate in the conciliation meetings. If others take objection. See, in the Shops and Establishments Act, the employee can directly file a case. He need not take permission from anybody. What is the status of an employee working in the industry? He is not covered under Shops and Establishments Act. He is covered under Industrial Disputes Act. Can you directly file? Radhakrishnan Murthy just said now he can directly file under the new code. No, even in Andhra Pradesh, Section 2 is there now. 2 is there. No, anyway, just I am discussing fundamental issue because since you gave an elaborate lecture, I don't want to bore them. Enlightened this thing.
My learned friend discussed about the Payment of Bonus Act, 21,000 employees, whoever is drawing up to 21,000. Basic and DNS elements are covered under the Payment of Bonus Act. For the purpose of competition, this 22, for the purpose of coverage, 21,000 is the limit. For the purpose of competition, 21,000 need not be taken. 7,500 are minimum wage, whichever is higher. And as far as the percentage of bonus is concerned, it will be worked out based on the set on, set off, allocable surplus. As you all very well aware, you must be having the background of commerce because mostly you are the company secretaries, right?
I'm not going deep into any subject.
No, 1 minute.
Just fundamental issues and discuss. Suppose if you want to debate, then many issues have to be debated. No, even 7,000 minimum wages are 7,000.
Minimum wages 7,000.
Not only 7,000. Either it is minimum wages or 7,000.
7,500 are minimum wage, whichever is higher. Whichever is higher, that is the thing that is to be followed as per the payment. When it comes to the Industrial Dispute Act, filing a case under the Shops and Establishment Act, an employee can file a case directly before the authority appointed under the Shops and Establishment Act. When it comes to the industry, before knowing that, you should be able to distinguish the difference between employee and the workman. Workman is different. All employees are not workmen. only few are workmen. All employees are not employees. The employees who are discharging the managerial and supervisory functions are excluded from the definition of employee. The employees who are discharging the managerial and supervisory functions are excluded from the definition of workmen within the meaning of Section 2S of ID Act. So they cannot approach the labor court. Any person who is discharging the managerial and supervisory. And another thing is that it is not the designation. It is the nature of duty that important. Designation means if anybody by virtue of designation gets excluded from the coverage of the act, you can as well call him as chief executive scavenger, just to escape him from the act. So it is not that whether he got the powers of supervisory and managerial powers. What are the supervisory power? Recommendation of leave, recommendation of increment, so on and so forth. What is the managerial power? Approval power, sanction power. Those are the employees. When it comes to the, I'm sorry, I'm taking much of Mr. Ashok Samrat's time. When it comes to the workman compensation, earlier it was workman compensation. Now they made it as employees compensation. Earlier it was confined only to certain of the employees. Now each and every person, even including the director, if he meets with an accident in the course of employment, can claim compensation under the employees compensation. The definition of employee differs from one act to the other act. It is not the same under all other acts, under the labor employment laws. Because definition of employee or a workman under the Shop Act is different. It is different from that of the Industrial Dispute Act. A Factories Act, the worker definition is different. And the payment of bonus, that is a different thing. ESI, 21,000, whoever is drawing, they are covered, irrespective of the designation, irrespective of the nature of duties. When it comes to the PF, 15,000 up to basic wage, they are covered under the PF. Over and above 15,000, if you are contributing the PF to any of the employees voluntarily, that is not obligatory. It is only the option. It is a gesture that is given that cannot be claimed as a matter of right. So there is a vast subject to be discussed about various compliances, part of it. But,
in fact,
and when it comes
again it went into lecture mode. I didn't want that.
No. When
I just I wanted to interact with you.
Yeah, not in the lecture mode, sir. It is in the elaborate.
That's my intention.
No.
No. It was lecture mode. I would have given all the things.
No.
That's not the thing.
It is not the question of lecture. What I mean to say is, suppose in the event, the Trade Union Act. Okay, let me Ashok. I'm just giving elaboration because left in between would lead to confusion. That is
No,
why-
nothing was left in between. Just I was discussing and it was in confusion.
If you have any questions further, we will answer it.
We'll answer it definitely. Because it was a lecture, this thing, I didn't want to have a lecture. That's the reason discussing the practical things. So as you said, Employees Compensation Act, it was Workmen Compensation Act earlier. Now that act, nomenclature itself is changed as Employees Compensation Act. As you rightly said, even a director is also covered by the act. And there is no salary ceiling. Some executive order is there, but it is not applicable. Like salary ceiling is not also. Even a person drawing 1 lakh rupees also can file a case under Workmen Compensation Act. That is Employees Compensation Act. So basically, I wanted to enlighten on Shops and Estates Act. It is very good piece of legislation. Andhra Pradesh Shops and Estates Act adopted by Telangana government after formation. Right from appointment till cessation of employment by way of termination, resignation, death, or any other reason, cessation of employment it deals with. All the establishment which are not covered by Industrial Dispute Act or which are not industries shall be covered by Shops and Establishments Act. They should register with the Labor Department. They should issue, all the establishments should issue appointment letters to all the employees. One copy to be issued to the employee, one copy to be sent to the Labor Department. The third copy should be kept with the employer for inspection and for record purpose. So it starts from that place. So within 3 days of appointment, that appointment is to be given. And the format is also given under the Act. Then leaves. What are the leaves to be given to an employee? The employee working under Shop Establishment Act is entitled for 39 leaves, 12 casual leaves, 12 sick leaves, 15 leave with wages, that is earned leaves. Out of these leaves, the earned leaves can be accumulated up to 60 leaves. The casual leaves and sick leaves lapses every year. So when taken into total leaves and holidays into consideration, 52 Sundays employees entitled, 39 leaves under the Act, then 9 national festival days. So total 100 days out of 365 days, the employee is off from the duty. Total 100 days he is entitled. So this is leave. Then the maternity benefit. Maternity benefit act, of course, Shop Establishment Act, there is a special provision, but now latest amendment is there for maternity benefit act. Now it is 26 weeks. Under new amendment, it is 26 weeks, 6 weeks prenatal, the remaining postnatal. And the benefit, the entire salary is to be paid by the employer to the woman employee. And if there are about 50 employees in an organization, then creche is to be provided. Compulsory creche is to be provided. And the lactating mother should be given every 2 hours time to go and feed the child. That facility also should be there. And termination is not easy under the Shop Establishment Act. There should be termination for valid reason. So, what is valid reason? For employer point of view is different and employee's point of view is different. Normally, see, nowadays we are seeing for software industries. Most of the software industries terminate the employees on some allegation of misconduct. So when it comes to the misconduct, the Act says compulsory you should inquire, you should issue a charge sheet, you should appoint an inquiry officer, you should conduct an inquiry. So most of the software industries, they don't conduct inquiries. They terminate the employees, and the resultantly, they are approaching the labor courts and particular authorities under the appointed in the Shop Establishment Act. And in most of the cases, the employees are being reinstated. So my friend just now said there is a bias, sympathy towards employees. So there can be sympathy because employees, when proper inquiries are conducted, this thing. So termination is not that easy under the Shop Establishment Act. There should be valid reason that they should conduct proper inquiry and terminate. And see, what is the age limit? There is no age limit, but after 58 years, one can be terminated. But the employee can retain the employee after 60 years, 60 years, there is no limitation. But 58 years after they can terminate the employees, they can ask them to resign. This thing. So that is healing. So basically, I covered leaves, I covered registration, I covered appointment letter, and I covered this thing. So, how many? There should be minimum service prior to this thing. So during pregnancy, suppose she joined after at the time of pregnancy, you are not able.
So at that time, the employer told her that you won't be eligible for the 6-month leave with pay because you are already conceiving. So can an employer make such kind of condition, and does it amounts to violation of Maternity Benefit Act?
Yes. See, there should be minimum service put in before conceiving.
Okay.
That is the law.
Thank you.
Joining the private show.
See, today you join pregnancy, you will not be able to. Anything? Even one change is there, they should provide fresh facility. No, that is not happening, sir. I can't probably prosecute for that. They will give for that. Even 2 or 3 cases in my hand, such kind of cases, they should provide even for one child. See, so I touched only fundamental issues for basic questions. If anything, other thing is there, I wanted to answer your queries.
After delivery, some months, the employer is required to pay with paid leave. So in that time, she is joining another firm. The new firm does not have an obligation to give any paid leave. What is the situation with the old firm from where she has taken, relieved? She has been relieved during pregnancy time, during maternity leave. If she has joined another firm, what is the situation with the liability of the previous employer?
As long as he is with the employer, the liability. If he resigns and goes away, then the liability doesn't persist, continues. If he joins new employer, how can old employer? No, she when she is comfortable getting a leave without by sitting in her house, why if she joins another employer, she will lose it. She will lose her. So I am not touching anything under the labor codes because they are not coming to operation. Lot of changes will be there once new government comes. We don't know whether they come into light or not. So I am not touching anything. Did you hear anything about EODB? What is EODB? EODB. Ease of doing business. Now government has given lot of exemptions, lot of relaxations in the name of ease of doing business. The previous is you need to file a separate return under bonus act, separate return under bonus shaft and act, separate under gratuity act. All the enactments you need to file separate returns. Now integrated return under EODB. Under all the enactments, you need to submit only one return. And under all the labor laws, now there is no direct filing of applications with the department for registration or license or renewal. Everything is online now under the name of EODB, ease of doing business. Under shops and district, you can get your registration and renewal. While we are applying for registration, you get the certificate. Just make entries, you make that pay fees, fill up the form, then you get a certificate with the proof. The renewal also you get a certificate or receipt. And see, all the enactments you get same way, except under Contract Labor Act. Contract Labor Act registration renewal you can get subject to approval. So UODB, we have a lot of concession to the industrial establishments. And inspections also, previously, whenever the officer wants to go for inspection, they used to go and conduct the inspection. Then straight away they used to prosecute. Now, under UODB, see, there are computer generated inspections. See, the officer, there is no choice for officer. Yes, yes. There is no choice for officer. So computer will generate establishment and officer. Then he has to conduct the inspection by giving prior notice. So if complaint is not there, just give a notice. Then he will feed the complaints report to the system. That's all. No prosecution, nothing. Anyway, there are so many issues. Since I got a say that I should wrap up. So thank you very much.
Thank you so much, sir. Now, Shri Radhakrishna sir would want to present the PPT as well. Thank you.
Sir, can I ask one question regarding PF it is? Nowadays, MCAS, sir is telling about ease of doing business. They have introduced one integrated form for incorporation of a company. In that form, apart from GST and bank account, we can have PF and ESA registration also. But there is no option to select S or no. It's a mandatory column. One has to select S only. So the moment we get certificate of registration, we are also getting PF registration as well as ESA registration also. Because of that, the name of the company is entering in the PF records as a registered person, as entity, in the ESA also. They are sending notices to the companies, though it is not applicable for the company because for 20 employees are not there at the time of registration. Yeah, even ESA also, but they are getting notices. So how to handle this? Because unless the clarity comes from department, for every company has to give reply. It is not applicable. They are telling that you need to pay 75 rupees minimum fee for every month, though it is not applicable to you by filing a nil return. It is not at all fair also. But legally, it is not applicable for that company. How to handle this issue? That's what our question.
The thing is that this online process is a boom as well as paid.
Yeah.
Paid because most of the times the server doesn't work. Paid because of the software is pre-designed. It will not accept and go further. Whether it is applicable to you or not.
Yes.
Out of complexity, that would say yes, and ultimately you turn into the new area.
Exactly.
For the sake of information. You see? So in the event, you have to make a representation of the effects body of the government that the PF ISA is not applicable by default by particular company.
Yeah.
Only when the threshold default of employment practice only
Yes.
happens.
Yes.
Therefore, the software has to be
Upgraded.
software
That's
has to be modified, has to be changed or redesigned so as to avoid these possibilities. These are the difficulties. Otherwise, you will be doing in a productive work, unproductive job by filing nil returns.
Yes, sir.
Where there is no work. These are the problems that
Practical issues people are facing.
Business at a time the cover doesn't work.
Yeah.
And they will be applying for a trade license to the municipal corporation by online, but they will not be getting. But surprisingly, the server does work when the person visits the office. No, this is what I get the complaints from the companies. I don't know whether.
Software, the system, what?
Yes, yes.
Yeah,
And naturally, this is beyond the words where I cannot say that you got to understand in between the lines, then you will get the meaning. That is one aspect of it. And because it's a vast subject, due to paucity of time, it is not a lecture what we get like someone said. In detail, what is taken up for you for the compliance part of it, what is the important topic, important service I did say. But if I got to tell about it, I should not touch it and leave it. I should fully tell it. Otherwise, you will leave with the door. Any act for that matter. Here the Trade Union Act for that person, whether the outsiders can be the office bearer. Section 22 of the Trade Union Act envisages that 50% of the office bearers can be outsiders, and there will be generally two sort of members in the trade union. One is the ordinary member, the other one is the honorary member. The ordinary member is the one who is actually engaged in the industry. Honorary member is the outsider, because 50% of the office bearers can be outsiders. The office others also, outsiders also can be the office bearers. This is what. As regards the participation, the case of State of India, where they said that outsider is not permitted to participate in the conciliation meeting, so on and so forth. Anyway, because if I got to say, you'll have to burn your midnight candle over there, and you would see the dawn, and you may not be able to leave at the dusk. That is right. I just made a presentation for this, where you would be able to just run through it, because it is not possible. Because and I have no objection if it is shared with you. It is a comparison between the present existing laws, and the new codes. What is the difference between it? And if you just have if you go through that, you can ask the organizers, the stock company secretaries. I have no objection, because I believe that anything stored is divine, anything shared is divine. Okay, so because it has to be shared, knowledge to be shared, and these are the comprehensive and exhaustive, not illustrative. And what I give, what the lecture, what I give is illustrative, not exhaustive, but the PPT is exhaustive, where you can go through. It is a self-explanatory, put it in the simple language, unlike the legal language, where in the legal language you often land into confusion, because active voice, passive voice, Ashoka planted trees, the trees were planted by Ashoka. Again, you have to restart again. That will be the confusion. So you can just have a run through of this PPT. I have no objection. Yes, these people, organizers of this Institute of Company Secretaries, they can share it. I have absolutely no objection, and you can leisurely go through it, because it itself takes a minimum of half day. If you simple reading, if you got to do a meaningful reading, it will take 2 days. There is a difference between reading and meaningful reading, right? Like I said, completion and accomplishment. Pardon?
For scrolling itself, it is taking much time. For reading it.
So this is the thing in nutshell. And if you have any queries, you can put it in respect of any of the labor laws. The thing is that, and the compliance, you have to just check it, what is the compliance, do's and do nots and other things. And is it the payment of bonus act? Payment, as far as the bonus is concerned, it has to be paid within 8 months from the date of closing of the financial year. And another thing is that you all must know in the organization, I'll just put it in 5 minutes, the disciplinary action. Like I said, there are two sorts of employees in an organization. And of course, it amounts to second presentation. I just completed that in an organization. Because there will be workman category, non-workman category, we are discharging the management and supervisory functions. And for them, the service conditions are governed as per the employment contract. There will be basically two sorts of contract. One is the contract for service, the other one is the contract of service. Contract for service is a business contract, contract of service is an employment contract. And as far as the non-workman category is concerned, their service conditions are governed as per the contract of service, not of the certain of the labor laws do apply to them, like employees' compensation, payment of bonus if their salary within the threshold of the age limit and so on and so forth. That is the thing. When it comes to the workman category or employee, if you got to remove an employee, you must be careful. Mostly IT sector, service sector, you will be having several agreements with the employees in respect of the IPR, patent registration, patent rights, invention, minimum service that they should put in. notice period they should, and they should not leave in between the notice periods, so on and so forth. All these clauses will be there. But in the mostly IT sector, what I come across is that they will be putting the employees under the PIP, performance improvement plan. When they are not improving, they simply say one fine morning they are called to the HR chamber and they will be asked, boss, your performance is not good. There is no record to prove that your performance is underperformance. You will say, this is what I named it as PPFT scheme. What is a PPFT? PPFT is place papers or place termination. That is PPFT. Either your place papers will get relieved, honorary you will get a service certificate, or else I will terminate you. That will become a stigma for your employment. Now, if you got to remove any employee for non-performance, you have to issue a charge sheet, conduct an inquiry, call for a check, call for an explanation, then issue a charge sheet, call for an explanation, conduct inquiry, objections over the findings of the inquiry officer, final show cause notice proposing the punishment, and then dismiss. You can't summarily dismiss, which is now happening. That is why in the courts now, mostly the cases pertaining to the IT are coming more and more because they are not following the procedure. This is why the procedure has to be managed. Another thing what you got to see is always drafting the employment contracts. But that is again non-competing. You will be having a separate agreement and non-soliciting. That when you let, you will be catching your employees and taking them away. And then also there is another clause in the agreement. Normally the employment agreements, you must be careful. And mostly the thing is that they copy from the other agreements, say that once if you leave the company, you should not work minimum period of 3 years with any other competitor. Then we will feed his family. And Supreme Court struck down that clause as the negative covenant way back. But I find in all appointment letters that clause. The clauses which can't be enforced, why do you put it and make the appointment voluminous, where put only limited clauses which can be enforced. Only positive covenant rather putting negative covenant so that it would be voluminous. Another thing is that Supreme Court in clear terms has categorically said the contract between employer and employee is the contract between lion and lamb. It is not a contract among the equal parties. It is a contract among the unequal parties. The employer just given consent cannot be taken as a free consent. So it should not be unilateral. It should be bilateral. It should be mutual and reciprocal. It should be reasonable. So it is a large subject. I can go on telling you from selection to subtraction, recruitment to retrenchment, various clauses into the appointment letters. But in nutshell, you can go through this. Then, if you have any inquiries, then you can ask.
Relating to notice of employees. As per shops and establishment, some of the IT companies or some companies, they are keeping 3 months notice period. Is it?
In respect of notice of employees, some companies take 3 months notice and 3 months of notice. Some companies say 1 month notice and pay in lieu of notice. Some companies say when I want to terminate him, I should salary overnight. But when he got to, I asked him to work, he should work minimum 3 weeks, 3 months or so and so. And some company will put a question to me, I have put the clause of 3 months on either side. Can I free relieve him without paying the wages? These are the normal. It is nothing but blowing hot and cold to suit the convenience. You should not prefer such contracts. Well, should suit your convenience, it should be enforceable. But as per the recently I came across a case in one of the IT companies, they have said that he has to give 3 months notice as per the terms of contract. But the Act supersedes the contracts. Contract the terms of your agreement doesn't supersede the Act. Whereas under the shops and establishment, it is clear. 15 days is the notice that has to be mandatorily given. Once after completion of the 15 days, he has to be relieved, and your contract won't supersede the Act supersedes the contract. When it comes to the law, even if the state is law, once if it is the president said, it is not the central or state, it still provides. Only thing is that when the rules are made, it has to be made in accordance and within the four corners in consonance with the Act. It should not go beyond the Act through the implementation process. So it is the 15 days. But when it is not, your organization doesn't come under the Shops and Establishment Act. For the non-workman category, you can put any condition, 3 months, 6 months, or whatever it is. But it is the law. It is a law contract. It is enforceable. Wipro is now queuing its ex-president, crores of rupees. There is a contract. So what there will be certain limitation permutation. Suppose if we say that he is not supposed to join with the competitor, he also has to provide subsistence allowance. Even if you pay subsistence allowance for the 3 years period, I can still challenge it. It can't be enforceable because today the technology what is today, tomorrow it becomes obsolete. A worthless would lead to worthless. Even if you pay me double the salary and ask me to sit at home, you will be still depriving my right to leave. Violation of Article 21 because I am outdated. I can still sue the companies. Right, Klaus? Thank you, sir.
We will now start with the paper presentations for the day on labor laws, Indian Stamp Act, and other revenue laws, along with banking, FEMA, and insurance laws. The first presenter for today would be Murali Karthik and Mr. Thomas K. Joseph.
They already saved it. No, they already saved it and they spent it as well. So, yeah. Program find it. Or this pen drive, I think you can just get it real time. It's not, you can get it. This pen drive, is not made. We didn't make it. No, we didn't make it. We got it through pen drive. Yeah. We saved it. They saved it. It wouldn't come in download. Yeah, I want to please it. Should have covered. Good afternoon to all the panelists and other professionals and students present here. Today, I am Murali Karthik, studying in second year, and my co-author, Thomas K. Joseph, will be presenting on the topic of contributory provident fund. So let us turn our attention to a critical concern with the contributory provident fund. It is basically the backlog of cases and the persistence of lack of awareness surrounding it. I believe everyone here is well versed with the topic of provident funds. Anyways, let us go through the gist of what provident funds is. A provident fund is a financial scheme where employees and employers contribute a part of the employer's salary to withdraw it towards retirement. The whole idea is to make sure an employee leads a good life after retirement. Right now, the Employee Provident Fund initiative taken by the government maintains approximately 28 crore accounts, which is quite impressive considering the working force of the Indian population. Okay, now moving on to the topic of contributory provident fund. It is now the most common retirement savings plan where both employees and employers have to make a regular contribution towards the fund. It is a form of social security and to provide financial stability to employees after their retirement. Under this, there are further divisions of permissible deductions and non-permissible deductions. So here, permissible deductions are recognized by the regulation, which includes standardized deductions. Standardized deduction is basically fixed amount set by the government for deductions, and itemized deductions. They're basic. They are based on the specific and documented expenses. If the total of your itemized deductions is lower than the standard deduction, it is more advantageous to claim the standard deduction. Now I call upon my co-author Thomas K. Joseph to take over the presentation.
Yep. Good morning, everyone. I'm Thomas K. Joseph. I'm currently pursuing my career in law, and I'm currently in my second year. And today I stand before you, not to sing the praise of a Provident Fund, but to shine a light on its shadows. Firstly, I would like to give a small case analysis on the case laws discussed in the paper. The first case law being the Nalanda High School and others versus Employee Provident Fund Organization others. In this case, the High Court of Calcutta clarifies the interpretation of Section 12 of the EPF Act by confirming that the employees cannot be compelled to contribute more than the statutory limit on wages under Section 12 of the EPF Act. The second law is by Mr. Arani Mukhopadhyay versus Employees Provident Fund Organization and others. In this case, the High Court of Calcutta highlights the importance of accurate record keeping by the EPFO. It also emphasizes the right of the employees to receive their full provident fund benefits, even if they face disciplinary actions during their employment. Now, Now, I would like to discuss a few issues of the Act and few possible solutions to the same. First being the backlog of cases. A study of July 2022 revealed that the EPFO had around 31,000 ongoing cases in the Indian courts. The reasons for such high amount of cases could be due to various reasons, such as complex administration, technological limitations, and etc. Such an issue can be tackled by giving fast and similar decisions on cases with similar facts. Few common cases that typically come under the EPFO is like cases where relating to housing related issues, disagreement over contribution rates, retirement and withdrawal related issues. Now, the second issue would be the lack of awareness. To tackle this, first we need to educate the working class and the upcoming working class about the laws meant for the Provident Fund in order to reduce the number of disputes and subsequently reduce the overload of cases in the judicial system of the country. Second, to create awareness of Umang. Umang is an app made by the Government of India. It offers pan-India e-government services and provide access to a plethora of Indian government services ranging from healthcare, finance, education, and many more. It even provides provident-related services and years to all grievances on the same. Now, the third issue being the lack of transparency. The EPFO does not disclose their investment portfolio and performance. Personally, I feel the disclosure of the returns can help quash the debates around the available surpluses and also help reduce the pressure on the government to maintain a certain minimal return in the event that adverse market conditions resulting in poor performance. Last issue being relating to security. Data security breaches and online frauds pose potential risk to members, personal info and savings. In August 2021, rupees 21 crores was stolen due to internal fraud at Mumbai Provident Fund office, where the raiders withdrew the funds and deposited them in 817 bank accounts belonging mainly to migrant workers. Such security issues should be immediately taken care of. I would like to conclude our presentation by stating that the EPF Act, while offering protection, faces challenges like backlogs, lack of awareness, and transparency. To weave a true safety net for workers, we must advocate for efficient dispute resolution, financial literacy, investment transparency, and a robust data security. By working together, we can ensure the EPF system becomes a beacon of financial security, not a symbol of frustration and uncertainty. I would like to thank everyone for giving me this opportunity to come and present here on the same. Thank you.
Now we would move on to our next presentation given by Dr. Shrujana on corporate governance in digital age.
Good afternoon, everyone. Am I audible?
Yes, you're audible.
Yes. Thank you. My topic of the session is relating to corporate governance in digital age. And if I start with the corporate governance in the digital age has transformed to the digital form, addressing the challenges and leveraging opportunities and it has been the successful tool for the corporate governance. And corporate governance is nothing but the set of principles, mechanisms, and processes used by various organizations to perform practices to run an organization smoothly. And we have been using this corporate governance in a digital mode more from COVID-19 pandemic onwards. The business practices, in fact, have underwent revolutionary changes, and they have transformed themselves into, digital form. And if you see the emerging technologies that make the corporate governance started adopting new technologies into the critical business practices as well. And if you see the most important goals of any corporate governance is transparency, accountability, and security. These three pillars, in fact, on which the corporate governance stands. These three pillars is a common goal for achieving a well-defined organizational structure embedded with the practices. In fact, if you see the stakeholders such as employees, clients, third parties, and other stakeholders, including board of directors, they form the backbone of corporate governance. And whether these three pillars, pillar goals of the corporate governance are taken forward intact, even in the digital age, is a question. And if you see that importance of transparency is something which says that nothing we should hide, and it is important as per the principle of transparency that we disclose all the practices which becomes an utmost important practice. In fact, it means that making its processes, that is business processes, visible to the clients, customers, internal as well as external stakeholders. This transparent system of corporate governance not only makes the outside parties track the disclosures of the practices, but it also ensures the top management where strategies and the formation of the decisions takes place. And if you take accountability, it is in simple terms means answerability. And and the same stakeholders in any business invest with a motive to gain profits. And whenever anything goes wrong, they need somebody to blame on, obviously. And that is a common scenario we see everywhere. And hence, having the accountability in the business processes plays a vital role. Okay. And this accountability, which acts as a medium it is ensured, the more utility to the people we can find. And if you see the integrity of a business, the ethical behavior of a business is all dependent upon the accountability. Equity of all the shareholders must be actually to be treated fairly and equally can also be ensured only when you have the accountability. So these three pillars have gone, whether actually I have focused my paper on whether the digital age has ensured these three pillars properly, or taking forward these three pillars of corporate governance or not. In fact, yes, we have this digital climate technology and the tools of technology that are supporting the corporate governance is really remarkable. And in fact, when I looked into the importance of technology or digital climate, I found that the corporate governance and the technology in the corporate governance has these few important goals. That is, automatic key business practices, processes for greater efficiency, centralize the management of legal activities, improve the security and decrease the risk, and ensure the transparency, broad visibility of management activities is possible through technology. And you can increase the efficiency undoubtedly about decision making and availability of even minutest data. Okay, digital technology, before digital technology was in use, the data, which is minute part, was not known to all of us. But after the digital age has has come, we are able to see not only availability but also accessibility of the data, minutest data. And we are able to identify and manage security threats through legal, whether legal, financial, organizational, or environmental. So these things, and apart from that, enhance the agility. Okay, keeping IT and all departments nimble to adapt to the constant evolution, acceleration, and increasing complexity of today's business world is one of the prime use of digital technologies. And disclosure are a mandatory part of transparency and accountability. We are able to disclose. However, unfortunately, the data vulnerability is also faced. So when you can see or identify the cyber security risks like data breach risks, business management risks, data governance risks, if you can find these three important identify these important risks and tackle the data properly, and that the digital age is a golden age. In fact, if you can identify the risks and take forward the digital age and use the use these digital technologies for corporate governance, obviously that sets a new era forward. Already it is happening. And however, I feel that corporate governance, though it is great, or it has revolutionized the digital age has revolutionized corporate governance, it is important that it has to have its own set of principles, processes, and procedures. And then definitely more and more great changes can happen. Corporate governance is in fact need of the hour. However, the digitization practices will involve the stakeholders more than ever before. Actually, with this, I conclude that more and more legal changes, if can be brought globally, okay, then automatically, if we can minimize the risks of the data protection aspects in the digital age, corporate governance can definitely take a leap forward by in this digital age than before. Thank you very much. Thank you for the opportunity.
Thank you so much, ma'am. Now we would like to move on to our next presenter, Shailesh Gohel.
Yes, ma'am. I'm not able to share the screen, ma'am.
Yes, you're audible. And you're the presenter as well. You can upload your PPT.
Okay. Just a second. Just a second. I'm doing this. Taking time, ma'am. Actually, few seconds.
Okay, you can continue without your PPT. That's fine.
Yeah. Sure.
We'll start
Done.
off. Thank you.
Good evening, all. My topic is that does the board composition impact? Yeah, it is there. Yeah, does the board composition impact the performance of the banks? A corporate governance study of Indian banks. So basically, what I've studied is this study attempts is to understand the core banking governance with a discrete focus on the constitution and operation of board of directors. And this is to be cognizant of the pivot responsibility of the board of directors has in overseeing in banks management and performance and their impact towards performance. So the study uses statistical analysis like t-test, correlation analysis, multiple regression to examine the board of directors presence and their impact on public and private sector banks, corporate governance, including resulting in performance. The finding of the study highlights the significance of strengthening intermediate directorship, promoting gender diversity, and enhancing capital adequacy management across the banking sector. So limitation of this study is that it is due to this limited sample size, which may not fully represent the entire banking sector. Moreover, this study has focused on a specific time frame
missing long-term trends and changes. External factors like regulator also impact this study. Further, it is increased database for future improvement in the database. It can be researchers can obtain the increased data set in conducting longitude study over extended periods. I have done the literature review. So, brief of the literature review is that this researcher, Adrian Cadbury, said that the corporate governance is a delicate art of bringing together social and financial objectives and individuals and community interests. So, Basel III committee also highlighted the safeguard the depositors' funds through stringent corporate governance procedures. Further research also found that the range differ for public sector and private sector bank is because of their ownership structure and their performance. The corporate governance was impacted during this financial crisis. And this we have also seen that during this past year there was many corporate governance failure. Like the first case was the Ramalinga Raju case, then there is ICIC case and many things. So it is due to this failure in corporate governance structure. The main objective of the research is to determine the significant difference in the existence of independent directors on the board of public sector and private sector banks to assess whether the existing of independent directors, executive directors, and women directors on a bank's board significantly impact on operating profit. Evaluate whether the existence of independent directors, executive directors, and women director on a bank board significantly affects capital adequacy ratio, and provide data-driven recommendation to enhance corporate governance framework in Indian banks, emphasizing regulatory compliance and board effectiveness. The research methodology that I have obtained is extensive and exhaustive literature review and focused on this existence of board of directors in public and private sector bank. So basically I have taken 10 banks, 5 public sector bank and 5 private sector bank. Public sector bank includes SBI, PNB, BOB, IOB and Canara. And 5 private sector bank are HDFC, ICICI, Kotak, Axis, and Dus Bank. So time period of the study is from 2016-17 to 2022-23. So it is 7-year period. So the independent variable that I have taken is a board of directors, existence of the board of directors, and the dependent variable I have taken is operating profit of both the private and public sector bank. And second dependent variable is the capital adequacy ratio of the both PSB and private sector bank. So hypothesis testing is that for descriptive statistics, it is a objective of the descriptive statistics is to provide an overview of the variables like board of directors, operating profit, and capital adequacy ratio. Independent sample test hypothesis I have formulated is there is a significant difference in the existence of independent directors in public sector and private sector bank. And for correlation hypothesis, I have taken 2 hypotheses. There is significant negative correlation between the presence of independent directors and operating profit and capital adequacy ratio in public sector bank. And second hypothesis is significant positive correlation between the presence of independent director and operating profit and capital adequacy ratio in private sector bank. And multiple regression, I have taken 2 hypotheses. That is existence of the board of directors of the bank has a significant impact on the operating profit. And second is the existence of the board of directors has a significant impact on the capital adequacy ratio of the bank. So data analysis and interpretation that I observed from the this variable, that is total director, executive directors, independent directors, and women directors. And ratio I have taken is capital adequacy and corporation profit. So interpretation is that private banks have more capital than public sector bank because of government support. And the second interpretation was that public banks have more income than private banks from the core business, because in the same case it is there are many government schemes that is launched by the public sector bank, and public trust on the private public sector bank than more on private sector bank. So it is this case. And the third interpretation it is the public sector banks have more board members and more executive directors than the private sector bank, because in public sector banks the directors are appointed by the government of India, while in private sector bank it is appointed by a bank with the permission of the RBI. And private bank have more independent directors and women than public banks. Yeah, because of the pay scale ratio and this skill oriented skill metrics and all the things. So directors are more attracted to this private sector bank than this public sector bank. So other this for independent sample test, I found that during this first 4 years of the study, there is a significant difference in the presence of independent director of the board of the public sector and private sector bank. And last 2 years or 3 years of study, it is found that during this year, the average number of independent directors in the public sector bank is not statistically different. So data for correlation analysis, I have taken two hypotheses. So output of the hypothesis was that the public banks have fewer independent directors and more executive directors than private sector banks. Private banks have more independent directors and higher operating profit than public sector bank. And private banks have more total directors and more executive directors than the public sector banks. So even in multiple regression, there were two hypotheses. This first hypothesis was to prove that existence of the board of directors of the bank has a significant impact on the operating profit. So result of the hypothesis is that independent variable hold a significant relation with means board of directors has a significant relation with operating profit and capital adequacy ratio. Second, it is that independent variables, that is board of directors, have a positive coefficient for operating profit. Third is this total number of director, executive director have negative coefficient for CER. Women director has a positive coefficient for CER. That is, public sector bank have lower operating profit than private sector banks. Further, the private sector bank has more financial strength and stability in public sector banks. Further, this private sector bank may face more competition from and market pressure from the public sector bank. That is correct. It is also found that public sector bank have more social and development obligations. Yeah, that is correct because of the government obligations. And the public sector bank have more regulatory and political interference. Yeah, that is also correct because in major public sector bank, the government is holding stakes. And public sector bank has the lowest capital adequacy ratio than the private sector banks. So recommendation is to improve the corporate governance of this banking. So recommendation is there should be deployment of enough independent director in the board of both the bank, that is public sector and private sector bank. There should be gender diversity on the board because based on the research, I found that there are less number of women director on the board. So there should be gender diversity on the board. So, and there is a there should be effective capital management in the bank. So it should be on the risk profile, and there is yeah, there should be focus on the anything profitability. So this it should be this decision making should be on the data driven use of artificial intelligence and machine learning, that is a present and more focus on the ESG parameter, that is also now one of the parameter of the governance. So there should be strict adherence to the regulatory compliance, that is also correct. So now conclusion, it is that there is a necessity for stronger governance in the banking sector, particularly in terms of the board independence. A recommendation presented from this research encompass the reinforcement of the board's governance and the promotion of diversity. Further, this finding bring forth the universal inclusion of governance and its far-reaching repercussion for organization performance and transparency. And ultimately, this study proposed the domineer need for continual assessment and enhancement of the corporate governance framework across the sector. So this is all about my presentation. Thank you.
Thank you so much. With this, we come to an end of the paper presentations as well. I would now like to invite CS Manmohan Sharma sir and request him to present Shri R.K. Sharma sir with a memento as a small token of thanks. If you could please approach the dais, sir. I also request Shri Nurul Hassan sir, Shri Radha Krishnamurthy sir, and Samrat Ashok sir as well to please come up to the dais. I now invite CS GSLN Gupta sir and request him to please present a memento as a small token of thanks to Shri Nurul Hassan sir. I now invite CS Vaidyanathan sir and request him to present a memento to Shri Radhakrishna Murthy sir as a small token of thanks from our side. Lastly, I invite CS Hari Upadhyaya sir to present a small memento as a small token to Mr. Samrat Ashok Kumar sir. I thank all the panelists for taking out the time from their busy schedules and being here with us today. Thank you so much, sir. I would now like to invite CS Latita Devi ma'am to present the conclusion for the event. Thank you so much, ma'am.
Good evening, everyone. Respected dignitaries on the dais, and Dr. M.R. Bhatt, former regional director. Good evening to you all and all the participants present here from all over the country. So I thank CS Venkatamana Garu, Chairman, ICSS CCGRT Hyderabad, and the Vice Chancellor of Nalsar University of Law for giving me this opportunity. Today we had the session. The session title is Labor Laws, Indian Stamp Act and Other Revenue Laws, and Banking and FEMA and Insurance Laws. So all the panelists are experts and eminent personalities in their own field. And we have with us 2 persons from regulatory authorities, IRDA Chief General Manager R.K. Sharma, sir. Thank you, sir, for accepting our invitation and chairing the session, and also for the your inputs for the session, and also the Samrat Ashok Kumar, sir. He is a retired Deputy Commissioner from Labour Commissioner's Office. He is also from Regulatory Authority. And I would like to tell you one thing here. We asked him to be the panelist only day before yesterday, not even this time. I think it is around 6 o'clock. After 6, we called him and asked him, sir, please come for the session. He readily accepted it. We went to the Labour Commissioner office day before yesterday. Actually, we approached the commissioner. We wanted him to come here. He said, I'm out of station. You can approach any of my joint directors or joint commissioners or deputy commissioners. And we went and approached Mr. Chaturvedi. He is the joint commissioner presently. He said, no, I'm not the right person. I will tell you a name who is the appropriate person, who is expert in this field. And we also approach him when we have any doubts. He told me in the same way. I was there, I heard of him, sir. Thank you very much, sir, for accepting our invitation in very, very, very short time. And Nurul Hassan, sir, is our family member. So he is our company secretary. And always, whenever we require for our seminars and all, he'll be readily accepting our invitation. And thank you, Nurul Hassan, sir, for accepting the invitation and coming here and providing the inputs about the insurance overseas, what are the compliances. Overseas also, you told me the differences and all in compared to the companies, countries and all, everything you have given the inputs. Thank you very much, sir. And also I would like to thank Sri Radha Krishnamurthy Garu, advocate and corporate legal consultant. Thank you very much, sir, for accepting our invitation and coming here. And we all have learned a lot from him. Like mitigation of litigation is always best, since the litigation is a speculation without knowing the destination. So your courts, different courts are very, very apt, and we learned a lot from your session, sir, today. Thank you very much for accepting our invitation and coming here, sir. Thank you. I thank all the participants for patiently listening to all the sessions today, whole day. Thank you very much. Thank you. Bye.
Will be touched.